Pardon to make a mention, my lord. This is the second memo. The first memo I have given on 8th September, my lord. It has already listed.
My Jamindar has brought me to the court 2 minutes early.
So, my lord, I will wait for 2 minutes, my lord.
1 minute.
For a wrong fixation of RSCP, my lord. This honorable court has granted interim order not to recover. Now what happens when the authority has reduced the pay of the petitioner during pendency of the case?
No, that's a different cause of action.
No, my lord. Basing on the wrong fixation of a pay, they have directed for recovery, and the such wrong fixation of pay they have now implemented and reduced the pay, my lord.
Next week.
Next Monday, my lord. This is the second, my lord.
Pardon to mention, my lord.
Yeah.
An assistant professor in the Ravensa University is not getting minimum lawful salary. Honorable Chancellor has directed, government has directed, but
2016 matter related to Ganas matter, 2016 old matter.
Same matter.
Yes.
Application, immediate application.
I think to mention the transfer matter taken on Monday.
Wednesday.
Monday matter, petition release matter, then
Is not relieved.
not delivered. On Monday.
Tuesday.
Says addition with petition or filed this litigation for paying for a direction to drugs inspector to issue the license, pharmacy license.
Pharmacy license.
Pharmacy license.
Immediately after vacation.
This is the urgent matter with a fresh matter, my lord. A proceeding, a show cause was issued to me, giving 7 days time, my lord. From 8 show cause issued, 7 days time was given. I asked for certain documents. They refused. No document will supply to you. You give a reply, otherwise you will take action within 3 days. 3 days is going to complete today.
Today.
My lord. But they refused to submit it.
Tomorrow.
Beg your lordship. Matter on the lordship board in the weekly list, that is item number 196. That is urgent in this legal news because that is the case relating to sexual harassment in an educational institution. There was that came to the notice of the government. Victims are the lady lecturers and the accused is the principal himself. So government brought on transfer order, transferring the principal to another college. By now, in the meantime, he challenged the transfer before the Honorable Court. However, subsequently that has been not placed. So that transfer order is valid, and also counter affidavit has been filed by the state here, your lordship in item 196, saying that transfer order is still valid, but the sub-collector who is the governing body president is not transferring him. And I am the next senior most lecturer in line. I was given the charge of principal in charge for some time. Again, because of the interim order passed in that earlier petition earlier, and plus I have been kept out of my duty.
But you are continuing as a teacher.
No, I'm just simply a senior most lecturer in that college.
Immediately after.
Plus, after vacation. Plus, can it take no one? Please,
No. But very good.
Item 18.
Pardon.
Yes, sir. Yes, sir. Item 18.
18.
Yes.
You want sign?
Yes, sir.
After vacation.
Anytime.
You are appearing there.
No, minute. I'm on another matter. Pardon me, Your Lordship. Lordship, item number 112 of the weekly list. My Lord, I understand, my Lord, I'm making a mention before vacation. Well, it was this case where it is admitted dues. Your Lordships were of the opinion that your Lordship were about to ask for personal appearance of the engineer. When my learned friend from the state said that, my Lord, please give us last chance, I'll take instruction. So, my Lord, that was posted today. My Lord, my only point is, my Lord, because, my Lord, at the end of the day, any delay goes from the pocket of the taxpayers because the interest at the end of the day will be paid by the taxpayers. It's an admitted dues, my Lord. I'm only saying, my Lord, and any other day, a specific date may be fixed so that it can be heard because they had taken time. Your Lordship wanted to fix a personal appearance.
Personal appearance of the officer.
Of the engineer, my Lord, who was supposed to finalize and send the bill. I mean, everything is ready, my Lord, for release. The Lordship said, why is it taking time? Let him come. My learned friend from the state said that, let me take last instruction.
First day.
112 minutes. Deeply obliged. 112 of the week. Deeply obliged.
Pardon to mention, my lord. Yes, admission. Retired benefit.
Retired
Benefit.
relating to pension.
Yes, my lord. Next week, any date, my lord? 2 matters, my lord.
Pardon to mention, Your Lordship. The petitioner is a vocational teacher of SCST department. Filed a writ petition for getting his revised scale of pay. Lordship.
RSCP,
Yes, sir.
not RSCP.
No, your lordship is a vocational teacher. File this for revised scale of pay.
Next.
Grateful, Your Lordship.
Yeah.
Item 1.
May I please, Your Lordship?
Yes, sir.
Lordships, the petitioner is before my lord.
Make use of the mic.
Sorry, ma'am.
Those who speak loudly, generally I favor them in some order. Yeah. Otherwise, you will violence.
Lordship, the petitioner is before my lord, challenging the arbitrary actions of the opposite party, my lord. In this case, what has happened? In the guise of the town planning, my lords, what they have done, they have displaced me from my original plot and they have allotted a plot in some other place, my lords. Despite the concurrence and the orders of two authorities, my lords, one of the sub-collector under section 29, another the vice chairman VDA himself, directing them to give me a plot at the same place which I used to have. They have not corrected the town planning, my lord. Lordship may kindly come to this, sir, when it comes to like the annexure 6. Because that's the order of the sub-collector, my lord.
Who recommended your case?
Yes, my lords. It was a case referred under section 29 when there is any dispute with respect to those situation of plots or ownership of the plots, my lord. Under the ODA Act, my lord, the sub-collector is the authority, my lord. Is my lord on?
Emergent notice.
Yes, ma'am.
Emergent. Learned AG Sri Lanka requested service notice.
Only for OP1.
OP number 1. Emergent notice 2. The rest.
Lordships, I have a IA, my lords. May I pray for a status quo, my lord?
Application is moved supported by an affidavit seeking a direction for maintaining status. First, the Net Counsel for the petitioner permits that if such a reprieve is not granted, there is all possibility of petitioner being dismissed. First off, there is prima facie case made out for issuance of protection, military protection. First, next one, in the above circumstances, application is favored and the parties are directed to maintain status quo till next date of hearing.
Grateful, my lord.
Item 2.
May you please, my lord. The petitioner is a member of the Housing Board Society who has been authorized by the other members to file this writ petition. Grievances of there is that they have purchased buildings, houses from the Housing Board Society of the society, which is a government organization, and they are in the possession of their building and they have paid all the money and other things. And so far the Housing Board Society is concerned, 10 acres of land was allotted for that society. They're having some open space.
To demarcate the housing project area.
The other persons now outside are trying to encroach upon the area of the Housing Board Society. Our grievance is that let them not to encroach upon that space to be remain for the playground, park and etc. for the society.
Take notice.
My lord.
Emergent notice. Mr. Lenka requested to accept notice for
12578.
12578. Emergent notice to the rest.
There is a IA also, my lord.
Let notice go ahead.
Obliged.
Item 3.
Item 3, may I plead, my lord? My lord, here in my lord, the petitioner is an institution. For opening of the same, he submitted an application before the appropriate authority. When no decision. Here the petitioner is an institution.
Yeah.
For some opening of the same, he submitted an application and that was kept pending. So he preferred an appeal before the government. And under Annexure 4, the appeal was disposed of, directing the HPC to do the needful within a period of 3 months, my lord. Till date, the same has not.
Identical matter, you lord?
Yesterday, item 16.
Yes, disposed of. Identical.
What we have said in that?
To consider that is opposite party number 3 in that case, regional director. Here also opposite party.
Opposite party number 3 is.
Take a decision in terms of the appellate authority order, that is minister.
Under Annexure 4, page 19.
Study serial number
16, 16.
1616. Just see the date, etc. Show me first.
Hopeless, madam.
Item 4.
The appointment under rehabilitation assistance scheme. Second level litigation, matter has been rejected and S8 on the ground that petitioner husband was an aided educational institution.
They have rejected your.
Yes, sir. Yes, sir. On S8.
On what ground they have rejected?
Petitioner husband was an aided educational institution, not a government, sir. Aided educational institution.
For aided education institution also compassionate appointment.
Yes, that I have to verify because in 90 rules that was aided was institution employees were benefited, but present rule has to be
request on request acceptable for the respond OPs. Call immediately after vacation since in short point is about. Yes,
Item 5.
Still or similar. My prayer is in page 10. I am the junior clerk working in the secondary education institution. My prayer is regarding enhancement of pay scale and also passing the annexure 6 and 10. This is a third round litigation.
In terms of resolution dated 29/11/2020.
According to that, yes, my lord. According to that, my lord, I have completed 4 departmental examinations.
Notice.
notice.
Any private party?
No. All are the. I will solve the copy.
Next.
Item 6.
Obliging.
Let's see.
Arrears of what?
Areas of my lord, after completion of 6 years of services, my lord, the petitioners, who are working as a teacher, and they have been regularized by the state government after completion of 6 years of services, my lord, and the similar situated persons who have been completed 6 years of services have also given areas.
Shall consider the representation.
My lord, if representation be disposed.
Petitioner is knocking at the doors of report, grieving against non-consideration of his or her representation dated 13/5/2025, a copy whereof is at annexure.
Annexure 8.
Annexure 8, my lord.
The 8.
Is 30.
First. In the said representation, she has sought for the grant or release of arrears of salary.
My lord, from 2019 to 2023.
That has allegedly accrued during the period between 2019 and 2023. First, the net counsel for the petitioner submits that the salary earned by an employee in an instrumentality of state, like the school in question, is her property, and therefore the same cannot be appropriated by the government. Which action first he also submits that right to property is constitutionally guaranteed under Article 33 and capital 1A, and capital E. First off. Next one, Mr. Lenka appearing for the AGA, Mr. Lenka appearing for the OPs, very fairly submits that he would instruct, we should consider OP4 number 4 to look into the grievance of the petitioner as has been held in the subject of presentation in a time-bound way and in accordance with law if all contentions are kept open. First, counsel for the petitioner accordance with this proposition. First, in the above circumstances, petition was disposed of, prescribing a period of 8 weeks for consideration, subject representation, and to inform the judge of such consideration to the petitioner in writing. Must delay will be viewed very serious. Now, no flaps. So,
all this connected.
All matters, my lord.
Common order we can common.
Item 7.
Petitioner continue as a data entry operator. File the second level litigation, file the challenging petitioner.
Louder submission.
Petitioner continue as data entry operator. Challenging
The operator.
challenging the rejection order dated 29/7/2025. Rejecting the case, my lord, petition. Similar order already issue notice, my lord.
You should notice.
Notice.
Urgent notice.
Not to disclaim.
He accepts notice for the all OPs.
No.
No.
Copy number 1 and 2, state.
1 and 2.
3, 4, 5 notices.
Emergent notice to the post. I call this matter along with WP.
I file for not to disengagement.
Yes, fine.
Yes,
The
sir.
responsible for the petitioner submits that in identical matters, common reprieve has been granted, and therefore the same should be extended to the client. First, he produces a copy of the interim order dated so and so, made in WP number so and so. So, in support of his conviction, first of the form of receivers. Next part, we have also application. What was the interim order granted?
Not to disengagement.
Not to
Disengagement.
paid out submission and dead submissions. Yes.
Till then, not
trained the OPs are restrained from disengaging the petitioner till the next date of hearing. Or you can make things reachable. Now, be clear in your submission. English is a very curious language, as any language. Unless you are very clear. If you read some of the letters, how I should understand? Already pronunciation is complete, yes.
Item 8.
The petitioner is the lecturer in Veda in Jagannath Sanskrit University. He joined in the year of 2011 for 1 year. And while continuing as such in the year of 2012, again through advertisement he joined. And in the
You
year
have
of,
rejected declaration now.
yes, ma'am. And also re-engagement.
On what grounds? Go to 21/7/2025. And
Yes,
yes,
sir.
16.
That's 66, ma'am. They're saying the regulation in the service in the post of assistant professor in Veda in the university cannot be considered the process of filling up the post as assistant professor is followed by a recruitment process through open advertisement following UGC guideline 2018. However, his application for reinstatement as guest faculty in the Department of Veda will be considered by the university authority during the selection process of guest faculty. The advertisement is to process in short period in the post of graduate and the session 2025 and 26, for which Dr. Sao is officially for selection of the guests and in the department whether if required by the department. Let's say I was continuing since 2011 to 2017, and despite order of this honorable court, they disengaged. Then, my lord, I was before this honorable court for regulation. And in the regulation case, this honorable court directed to consider the case, and they have considered this way. And
What is wrong with this?
wrong this, not I am continuing for 6 years, and there is the circular of the government that for 6 years. After 6 years, I am entitled for regulation, but they are saying no, you are disengaged in
2017.
Yes, ma'am. And 6 years completed. And in the meantime, they have said, no, you come with the advertisement. In the meantime, my age is over.
You have become age barred now.
Yes, ma'am.
Issue emergent notice. AGA.
No. That's notice will go to the university.
Returnable within 4 weeks.
Item 9. Item 9.
Well, let's see. On the 26th, the similar matters are coming.
Which is that?
WPC number 22057.
Call along with WPC.
Number 22057/25. Those are some of them.
Yeah.
No, sorry.
Nine.
May not be.
No.
That may not be.
Not matter.
Yes.
Notice will go.
Issue emergent notice. 4 weeks. So, yeah.
Item 9.
9 and also I'm praying for Passover. Passover.
Yeah,
I am praying for Passover.
Passover.
Item 10.
Yes, my lord. The petitioner is challenging the order number 1437 dated 11/7/2025 passed by the block development officer Bongomura in the district of Balangir, my lord.
Saying
The fact is that, my lord,
what the order says.
order, my lord, the petitioner vehicle is no more required. The petitioner four-wheeler vehicle, my lord, engaged before the block development officer on the basis of hearing basis, my lord. Hearing basis. But as per the term and condition of agreement that is annexed here to, my lord, point number 11, 10 and 11, without prior notice, the block development officer cannot be stop the vehicle or disengagement.
Where is that condition?
Your Lordship may kindly say pay number 12, annexure 2, 10, my lord. If
Services are found to be unsatisfactory,
found to be unsatisfactory,
shall give 1 month notice and the agreement will be terminated.
yes, my lord.
That 1 month notice is not given to you.
Not given, my lord. Your Lordship may kindly see annexure 3, my lord. That is the disengagement of my vehicle without prior notice. The block development officer violated the term and condition of the agreement.
Issue emergent notice. Learned AG is requested to accept notice for the please. To make a statement on Friday. We'll call this matter on Friday.
Coming Friday.
Because his life may be depending upon the vehicle itself. Maybe that he has bought the vehicle with
Yes.
loan.
Yes.
If you all of a sudden say, go home, what he should do? Because there is an agreement and it stipulates also.
Yes.
Or you continue him till next date of hearing. I give that option to you.
I have no instruction whether already he has been.
No, already means it will be sent to his house. Again, it will be driven to the office. There is no taking of charge and other things, no ceremony.
But serious allegation against him. That's why you are showing that.
It's all right, but at least immediately
You not should call it next Friday.
call this matter.
But I have a I am, my lord.
That's what. Therefore, I said on Friday he has to make the statement. Or we'll say that let him, you engage that vehicle till next date of hearing. Nothing will happen. After all, he will give service.
Yes.
And I will put him to condition.
Yes.
An application seek issue emergent notice, he is requested to accept notice and he accepts. First, an application supported by the affidavit is filed seeking interim protection so that the vehicle will be engaged by the second OP BDO in terms of the agreement dated.
Agreement dated, my lord, 9/12/2022.
9/12/2022, a copy whereof available is the A2. First one. Council draws attention of the court to condition numbers 10 and 11 in the agreement, which prescribes 1 month prior notice as a precondition for termination of the contract in question, and says that these conditions are not complied with. First up, prima facie there is a pause in the violation. First up. Next paragraph. In the above circumstance, the OP number 2 is directed to engage the services of petitioner subject vehicle in terms of the agreement till the next date of hearing.
Item 11.
A teacher was disengaged from service in 2010 on the allegation of involvement in a criminal case. After acquittal, I approached this unquote person to the orders, person direction of this own pilot. I have been reinstated in service. I pray for back causes. Back causes in terms of the for the period. They rejected my claim because you have not worked in that period, my lord. I am fortified with the Supreme decision. I have quoted it, my lord. Paragraph, page 7, paragraph 5.
Countable.
You must just notice. AG8 works of notice. Yes. But how? no pay, no work, no pay principle will apply there. What is there for? If you are in involved in a criminal
Not
case,
sir. I have acquitted in 2012, my lord.
Yes.
They delayed for more than 30
Reinstatement.
reinstatement. After acquittal, that is Supreme Court decision. After acquittal, I am entitled for acquittal from the date of demand after acquittal.
Yeah. Govinda Malia.
Govinda Malia and Supreme Court decision also in Muhammad Abdul Rahim's case 2013-11 SEC.
Oh. Emergent. EG accepts. Yes.
Item 12.
Please, Lordship. Lordship, this petition, the petitioner is seeking the first, second, and third RACP benefits minutes.
Similar matters we have
Yes,
other
minutes.
emergent notice. EG accepts notice for OP numbers.
OP number, all the OPs
All
minutes.
OPs.
No, except 5.
Except
Five is headmaster. Now there is no headmaster is there.
Headmaster.
Emergent notice to OP. All along with WP number.
WP number minutes. Not similar matter. This is the single I have 5 minutes.
Similar matters are we have written. Call in the third week of October. Let us.
Item 13.
Here the petitioners are retired teachers.
Yeah.
After their retirement, they applied for commutation a portion of each pension, and accordingly pension was commuted.
Make use of the mic.
Yes. After their retirement, they applied for commutation of a portion of each pension, their pensions, and that was allowed. And the amount of recovery was fixed, and the amount of recovery has they have already paid the amount for 10 years. But it is calculated that after 8 years, 5 months, the entire amount they have committed that has been recovered from them. And
And 20%, that is 20%.
that will go on after till 15 years. That means double the amount they have taken. And this matter was, similar matters are pending before this court, before this honorable court. And you will also kindly see.
Brother,
Next
Crime's judgment.
Yes, yes.
They should notice.
And
issued in a series of matters. The new amendment in 2015 that came, notice was issued. It was not.
Annexure 6,
EG is requested also.
yes, Annexure 6.1, you will also kindly see. Page
Any
14.
interim order is granted.
Yes, in that case, the interim order has been granted. That no recovery till further orders. Not these 6, Annexure 6.1.
An application supported by PA moved, saying that there is urgent need to stay the recovery. First off, the Learned Counsel for the petitioner submits that in identical matters, the coordinate bench has granted the interim protection in WP number 25294 of 2024,
6.
and therefore,
You will also kindly see page 16.
all right,
Yes.
the same protection needs to be afforded on the principle of very first off. Therefore, in the above circumstances, recovery is halted till next date of hearing. Okay.
Both the cases are similar.
Same. Okay.
Yes.
Same.
Item 14.
Item 14 can permitted withdraw my lord. Liberty to file better application.
14, you want to withdraw?
My lord.
All the cases.
All the
The
cases.
counsel for the petitioner seeks leave of the court to withdraw the petitions with the liberty to approach again afresh. First off, learned AGA Mr. Lenka, accepting notice for the other side, does not object to the proposal. Next paragraph. In view of the above, petition is already disposed of as having been withdrawn with liberty as sought.
All connected.
All the cases.
All
Same
connected.
order.
Of like process.
Item 15.
The petitioner is getting provisional pension, but the authority has not yet sanctioned the final pension, my lord. Annexure 1 is the extract of service, Annexure 3, recommendation to the DO, my lord, regarding delay in finalization of pension papers and all other documents, my lord.
You finalize the pension in terms of Annexure 28 for 25?
representation 3, annexure 3, they are getting the provisional pension.
Correct. Petitioner's short grievance is against the delay in finalization of pension on regular basis. First one, counsel for the petitioner draws attention of the court to petitioner's representation dated 28/4/2025, a copy whereof avails at annexure 3, wherein he has aired his grievance as to the delay on the ground that non-forwarding of proposals regarding pension papers, including CVP, ULS, DRG or DCRG? DCRG, by the headmaster of the government preschool. First, he submits that when such a representation is given, the same should have met its fate at the earliest point of time, pension being not a bounty, but a right in the light of D.S. Magara versus Union Office, 1988 SC, exercises in 84, 85. Just learned expert, learned AGA on request of hearing for the OPs, in all fairness, submits that he would instruct the jurisdictional OPs to look into the grievance of the petitioner as has been aired in the subject representation in a time-bound way and in accordance with law, if all contentions of the parties are kept up. First, with this proposal, counsel for the petitioner is agreed. In the above circumstances, it is solicitable. Now, no cause.
Item 16.
If the petitioner is holding in class 4 post since 2001, my lord, had approached the London State Education Tribunal for approval of his service. As the tribunal on contest allowed the application annexure 1 since 5/7/2023. But still that the judgment has not been implemented despite the execution case pending since 24 January, my lord. And recently, you also passed similar order in regarding the Rahul Shah. Now recently, when affects in 2025. Also kindly see one paragraph.
That my order you can give.
Yes, you also ordered in 2 orders. Single bench. Now, you also kindly see one judgment, recent judgment passed by the Apex Court, exactly on the same case. Like the Rahul Shah.
Short grievance of the petitioner is the long pendency of his execution case number
1 of 2024.
1 of 2024. First of he presses into service the Apex Court decision in Rahul S. Shah versus Jinendra
Gandhi.
Yes.
2021 6 SCC 418.
And this same judgment also.
And also,
this is the
how many? One decision, sir.
This is the one also kindly see para 74. Relying that the mandatory direction contained in Rahul Shah, this is Supreme Court direct, my lord.
And Periyammal versus V. Rajamani, 2025 INAC 329, to the effect that execution proceedings have to be accomplished on a war footing. Outer limit being 1 year.
6 months.
6 months.
6 months.
Next one.
6 months. Rahul Shah 6 months. This is also 6 months.
6. First one.
Rahul Shah is 1 year.
No. Rahul Shah 6 months.
I read 1 year.
My lord, it is 1 year.
Paragraph.
My lord, therein it was pending for a decade.
Correct.
But this is a 24, my lord.
Correct.
And the recent judgment, my lord, that is 6 months.
Just saying that outer limit being 6 months. First, next one. Learned AGA Mr. Mohan P. submits that maybe because of work pressure, sometimes the delay is occasional. And he would instruct the presiding officer in the execution case to dispose it of in terms of the decisions cited above, if all contentions are kept over. First, with this proposal, counsel for the petitioner is agreed. Next paragraph. In the above circumstances, the petition is disposed of fixing a period of 3 months for disposal of the execution proceedings. First one. All contentions of the parties are kept also.
In other case, on Annex 3, you'll also observe that tribunal shall dispose of matter and outer limit 4 months and report compliance to the Registrar General, failing which it is open for the petition.
4 months. Compliance to the register, reporting to the registrar of this body. Which an application will be moved to take appropriate action, penal action against the concerned body.
And the same judgment apex would also say that the High Court should take initial action against the period officer on arbitrary side.
In the second case, I have not seen that.
Para only one para, 75. This is one last operating person. If the direction is yes,
yes, next.
Item 17.
The petitioner is the retired lecturer from retired college Melon. And at the time of retirement, he was getting 5 lakhs Melon for gratuity Melon, which is contrary to the statutory rules Melon. The similar point Melon, the WPC number 35958/22, has any pending Melon, the government has a filed counter Melon. Let's see, color this matter along with that.
Issue notice. Learned HEA, this monthly access notice for the office. First up, call this matter along with the WP number.
WPC 35958
35958
of 22.
2022.
Well,
soon after vacation.
the sub-item is also same. Well.
Next, that's also same.
Same.
Oh.
Same part.
Same one. Both the same. Okay. Yes.
Item 19.
Thank you.
This is the matter regarding grant of family pension.
18 adjourned.
It is urgent.
By a grant of family pension to the pensioners with divorced daughter. In Orissa pension rule, divorced widow.
Divorced daughter is also included.
Entitled, my lord.
Provided at the time of death, divorce should have happened.
Yes. That is their interpretation, government's interpretation. But that is Annexure 7, page 22. They have rejected on that ground, my lord. That there is dependency is the main cause to be determined whether he is dependent on the father's on father and mother's pension or not. In this case also there is no maintenance granted, and this is also going on.
What the husband was doing?
Husband is police constable.
What is the amount you have received after this?
No, there is no, that is the point, my lord. We have, that I have filed that judgment of this honorable court.
How many years of service he had put in?
The husband is young, 47 years old only. And that is a judgment, my lord, I have given on page 17. This honorable court.
No, it's the husband's duty to look after.
My lord, everybody will abide by duty, then this country will...
No, this cannot be given. Husband also in employment, you are also in employment.
No, I am not in employment.
No, you want employment. How? There are 140 crore people.
I have no source of income, my lord, because I am already 45 years old, petitioner.
When husband died?
No, my
husband
father
is there.
No, my father.
Father has expired.
But widowed daughter.
Not with divorce.
Not divorced daughter. Divorced daughter.
My lord. I am claiming because this is the order of this honorable.
Divorce took place when?
My lord, that is 10 years before when mother was there.
Kindly give the date.
My lord. That is the date of judgment is 25/11/2019 and divorce filed on the 15, my lord, 2015 in ex parte. That order is also ex parte order. So I have filed a recalling of order that is dismissed then before this honorable court.
Death of father happened when?
Father
2008.
Huh?
2008.
2008.
7/5/2008.
And mother died on 20.
7/7/2019.
You don't have any property, anything. Have you disclosed everything?
Everything, my lord.
Where have you disclosed all that?
That is in the affidavit before this honorable court I have filed. I was staying at somebody's place here, and doing some house course activity because there is no paternal property and brothers. One of my brother is there in the village, so. And this Honorable Court set aside that ex parte orders and sent back to the court below. But in that court also, the husband is not taking any.
Have you moved any application for maintenance there?
That I have filed, but it is pending. That
Will direct them to consider your application.
Because my lord, this case is.
No, otherwise it cannot be given. Death is not a ground for granting benefit.
But that is the rule.
Died in 2008, 7/5/2008. All these years you have been very.
No. My separation started in 2015.
Yes.
I am with the
7 years. After 7 years.
I am with the mother. Mother was getting pension. After mother's death, I am destitute. That's why I have filed my lord. Kindly see that I have quoted the rules.
Where have you stated in your interim application that the mother was looking after me? And after her death, nobody to look after me.
Yes, that's
interim application before the family court. Show that.
Family court application is not.
Then you cannot draft here.
No.
What is the stand you have taken before the family court? Show that.
Yes, my lord. I'll bring that petition. You'll also may adjourn it because I have only filed. My lord, kindly see page 5. That is the OCS pension rule I have quoted.
No, question is not that.
Yes.
What is the stand you have taken before the
my lord, I have no source of income and husband is not paying also.
No.
I will file that.
Petitioner to produce
My lord.
the case papers in the family court case. That is, what is that case number?
That is, my lord, that I have annexed. That is filed by the husband, civil proceeding number 239 of 2015.
CP number
239 of 2015, Annex 3, page 9.
2015, in its entirety, feeling which adverse inference may be drawn and petition runs the risk of dismissal on that ground itself.
My lord.
Call immediately after vacation. Yeah.
Item 20. My lord, in this case is second round litigation, my lord, challenging the order dated 17/5/2025 passed by the opposite party number 4, registered Revenue University, Kottang, my lord, not regularize my service.
How many years of service you have?
My lord, 11 years, more than 11 years.
Issue emergent notice. Yes.
Item 21.
In this case, my lord, petition praised for grant of headmaster scale of my lord. That is similar order or that is in past.
We have passed the have you changed the date?
Yes. Already I have corrected. Other two methods are same.
Same.
Yes.
Okay. Separately you have given.
Already I have corrected all the
Which stability will that which one? Won't be acceptable. Next.
Item 22.
May please, Your Lordship. The petitioner.
Yes, sir.
The petitioner is the principal in charge of Chittolo Degree Mahavidyalaya, my lord, at Jashpur.
What is that order 11/9/25?
Ma'am, that is the order at Annexure 11, Your Lordship, which is under challenge on the ground that, first of all, there being no common cadre so far as the petitioner not being in the common cadre purview, transfer and appointment of a principal from an outside institution is not permissible. And that is number one. Number two, Your Lordship will see, I was appointed as principal in charge under Annex 2 at page 21. Then my lord, report was sought for. My lord, report was submitted by the my lord, president of the CB, my lord, at page 24, Your Lordship will see, indicating that the senior most person available there is disqualified having criminal case. So far as I am concerned, my name is at serial number 2. I was given a my lord, go ahead with affidavits I have filed. So far as the recommendation is concerned. I filed a writ petition because of the fact that it was not considered. Your Lordship will turn to page 30
after the criminal case was launched against the senior most,
No,
who was holding the,
I am holding the post because there is annexure to the order is there. I am the principal in charge.
since how long you were holding?
I am holding it since your lordship will find 11/3/2025 is the order at page 21. Now, for except to this, the recommendation was sent on 23/2025 annexure 3.
Who?
23.
To whom it was sent?
It was sent to the government, special secretary to higher education department.
For approval.
Because they called for a report with regard to the suitability. And suitability in page 24, the recommending authority says that the first person in the line is having criminal cases and the second person, that is the present petitioner, has filed affidavit expressing his willingness and there is no hindrance so far as his appointment is concerned.
You are number 2.
Number 2.
Then what happened?
Then what happened? Since it was not considered, a writ petition was filed by the petitioner.
And consider.
Well, your lordship sees there was a direction.
The order, you can say one line.
It was directed to be considered.
That's go to next.
Then Niranjan Panda files a writ petition. The person who was
criminal case.
Then direction was issued in his case also. Now the authorities picks up that direction, not the direction issued in my case, and decides both the whether I am suitable or he is suitable or not. Now,
where you made a party in Niranjana Panda's case.
Niranjan Panda's case, my lord, that is not briefed to me. My lord, that is possibly I am not a party here.
You were not a party.
No. Now, what they have done, they decided. Now, without any justification at page 38, Annexure 7.
There are 2 orders to consider 2 rival representations.
True it is.
Factually, that is true.
Absolutely.
No, your contention is your representation ought to have been favored and not his.
But in fact, he has been also held to be disqualified. But simultaneously, I have been held to be disqualified.
On what ground?
There is no reasoning, your lordship, that is commencing from page 38, your lordship sees.
Disqualified by whom? By the authority.
The special secretary has held that I am not eligible to hold the post.
Special secretary of?
To the government of higher education department.
Why he says that?
That your lordship will kindly come to page 39, the last para.
Annexure 7.
He says allegation for coming to the college intoxicated, abusing the staff.
Yes.
This was not in the recommendation. And this were from the authority court, they know it better. But this was again challenged for this noble court in a writ petition. Now, this noble court has been pleased to entertain the writ petition, notice has been issued, and the this noble court has been pleased to direct that the impugned order shall be subject to the result of the writ petition. That is at page 45.
So there is no interim order.
But I have to tell I have to submit the facts before your lordship. But that is also annexed.
What happened to that petition? It is still pending.
It is still pending.
We call this matter and that matter together and decide it within 1 day.
My lord.
Because a person involved in criminal case cannot be placed in charge.
No, I am not.
A person who goes on drinking also cannot be placed.
That has to be, that should be some material.
No, anyway, court is examining it. It did not grant you the interim order.
Well, true it is, madam. I am not disputing. I am on a question.
What message the people will get?
But if your lordship gets any material regarding that.
Therefore, we will post both the matters together and hear them.
My lord. Now, one more thing I will point out. The other part would be whether the outsider should be brought. Maybe the third man.
We do not.
My lord, that is the question.
Instead of a criminal and a drunkard, any person from the market has...
Outside that, your lordship has been pleased to hold that it can be, because in the absence of a common cadre.
Though our constitution...
The third man has to go. Has to hold in charge. If at all, I am held to be disqualified. If at all.
Though...
whosoever comes 3, he will be in charge.
Though our constitution does not prohibit drinking. There is one poem by John Keats. Give me woman, wine and snuff, till I cry hold enough. You may do so sans objection, till the resurrection. Something like that, the last line. In fact, that in which is that famous judgment, I don't remember. When prohibition was imposed in Bombay state by Morarji government, the then Bombay government. Mr. Daftari told India is no longer a republic. And judges asked, why do you say that? No, now pub is removed. What remains is only relic. REPUBLIC. Very witty lawyer, second Attorney General of the country.
My lord. Here,
Not in the school.
no, my lord. Here the question would be only whether I should be condemned or not. That also, your lordship.
Let us see. Call this matter along with WP number. Give them.
My lord, that WP number is, my lord, I have also mentioned.
Immediately after it.
And that is 18744 of 2025. I'll humbly pray, can it be
Immediately after vacation. Otherwise, he will sit even during the vacation period with a bottle on the table.
My lord, may I pray? Can it be in the reopening if your lordship pardons and permits, my lord?
On 10.
I'm so grateful, my lord.
13. Then we have one function.
And will your lordship put a notice on my petition to
Yes. VGA told some notice. Serve copy also. And emergent notice to any private party.
My private party is there, my lord. That is opposite but now 5.
Fine. Okay, fine.
OP number 5 was 5 misread.
That's what.
My friend was goading me to pray for an interim relief.
I pray you not to press it.
But I have not pressed it, my lord. He was goading me, I just pointed out.
It is like saying,
I was little religious.
suppose if there is a prohibition, there is a direction not to drink, then it comes to saying, sir, I will not drink. I will keep the bottle just open,
my lord,
on the table.
Man, this has come from nowhere. That is the ground person who is there. He has not said that. So that is the difficulty. But anyway, it is for 13, man. I'm so grateful, my lord. I'm filing my appearance memo also.
Yes.
The courtmaster is asking my name. I have given. But I'm filing my appearance memo. What else? Oh, that case number.
Yes, that's what it's possible.
Anyway, for the information of the courtmaster, I am Samir Kumar Mishra.
Next.
Item 23.
May I please, Lordship?
Yes, sir.
Lordship, actually this writ petition is filed to seeking the direction to the opposite party number 2 to investigate the matter pertaining to the inaction of the opposite party number 4 and 5 on the representation dated 5/9/2025 submitted by the petitioner against the opposite party number 6 and 7 in view of the Hon'Ble Apex Court judgment passed in Dr. Subramanian Swamy versus Director CBI Lordship, as well as seeking the interim direction to the respondent number, that is the opposite party number 4, to issue scheduled caste certificate to the petitioner in view of the Apex Court judgment passed in Yogesh Mahadev Makalwad versus State of Maharashtra Lordship. Lordship, while going to the facts of the case, Lordship, the petitioner...
Take notice.
They are seeking a direction to the option number 2 is the CBI. It is regarding caste certificate.
Lordship, actually there are many allegations against the officials, Lordship.
Item 24.
Deeply obliged.
Honorable Poti, I prefer passover.
Passover?
Lordship.
The amendment is. Item 25? No, 24 matter in the earlier occasion, Malaysia said for necessary correction and amendment in the prayer.
Yeah.
That release of that the bank guarantee, keeping in view that cloth rules. How they have sought for Passover.
25.
That matter I have sought for recall of your.
My lord, I appear in VC, my lord. If your lordship, am I audible, my lords?
My lord.
Yes, Mr. Parida.
Yes, my lord, lordship may see order number 2. Your lordships have passed an order on 16/9/2025 minutes. May I place it, my lords?
Yes.
An application is moved by the learned member of the bar who claims to be a one-time office representative of the Bar Association for recall of the order dated 9/9/25 made in WPC number 24143 of 2025. He draws attention of the court to the amendments in the petition filed by the party in person. Since already the matter is disposed of and the application therein is moved, propriety requires that notice of the application be served on the party in person by special messenger immediately. Ordered accordingly, the notice is made returnable on 18/9/2025. Cost of the special messenger be assessed and requisites be filed in course of the day. That was all done. it is open to the applicant to serve a copy of the application in addition to usual steps through his email ID if available. Call this matter on 19th September. In the meanwhile, the operative portion of the order dated 9/9/2025, to the extent it accorded liberty to the petitioner to explore remedies elsewhere, is kept under suspended animation till the next date of hearing. Copy of the order, web copy of the order to be acted upon by all concerned. This is an unfortunate application which was filed by way of a writ petition before your Lordship's minutes. And I had an occasion to go through it. It is peppered with allegations against this honorable court, which not only scandalizes and tend to scandalize the court, but also seeks to lower the authority of the court, seeks to interfere with the obstruction of justice and malord administration of justice. In my humble submission, it satisfies all the requirements of criminal contempt as defined, my lords, under section 2C of the Contempt of Courts Act 1971. And it's a fit case, my lord, where your lordships will take so much cognizance of the matter and issue notice for contempt. That's my humble submission. For your lordship's kind consideration, my lords. I have looked for some judgments. The closest I got was one in the case of Ajay Kumar Pandey, judgment of the Honorable Supreme Court. I will ask one of my colleagues to hand over the copy of the judgment to your lordships, for your lordship's kind consideration. My lord, this was a case. I'm so sorry, my lords.
Yes, sir.
This was a case, my lords, where allegations were made against the subordinate judiciary. And if my lords are kindly pleased to come to page 259, paragraph 18. My lords have paragraph 18, my lords.
Yes.
Page 259. My lords have it, my lords.
Yes.
Para 18. The rule of law, may I place it? The rule of law is the foundation of a democratic society. The judiciary is the guardian of the rule of law, and the judiciary is to perform its duties and functions effectively and remain true to the spirit with which it is sacredly entrusted. Kindly note, my lord, sacredly entrusted. The dignity and authority of the courts has to be respected and protected at all costs. It is for this reason that the courts are entrusted with extraordinary power of punishing those for contempt of court who indulge in acts, may not kindly see, who indulge in acts inside or outside the court. Now this is important, which tends to undermine the authority of the courts and bring them in disrepute and undermine the authority and in disrepute and disrespect, thereby obstructing them from discharging their judicial duties without fear or favor. This power is exercised by the court not to vindicate the dignity and honor of any individual judge who is personally attacked or scandalized, but a view to uphold the majesty of law and the administration of justice. The foundation of the judiciary is the trust and the confidence of the people in its ability to deliver fearless and impartial justice, and as such, no action can be permitted which may shake the very foundation itself. My lord, then they refer to paragraph 19 as to what is contempt of court. And my lords may see, my lords, it satisfies, this application, if your lordship read, satisfies all the ingredients. Scandalizes or tends to scandalize, lower or tends to lower the authority of any court, prejudices or interferes or tends to interfere with the due course of any judicial proceeding. My lords may kindly turn over the page, my lords. Interfere with or tends to interfere with or tend to obstruct the administration of justice in any other manner. My lords may now kindly see paragraph 20, because they have said that the expression publication also includes pleadings. Does my law have it, not have it? Para 20?
In Delhi Judicial Service.
I'm grateful to your lordship. Your lordship knows all these judgments. I'm only carrying coal to Newcastle. Kindly see, my lord, just after the quotation, that the term publication contemplated by section 2C of the Contents of Court Act 1971 includes pleadings, affidavits which are filed in the court is no longer in doubt. My lords may see a few more paragraphs. Kindly come to page 263, para 24. My Lord, sir, page 263, para 24, my Lord.
Thus it is now settled.
Thus it is now settled that the abuses, attribution of motives, vituperative terrorism, and scurrilous, not kindly note, scurrilous and indecent attacks on the impartiality of the judges in the pleadings, applications, or other documents filed in the court or otherwise published, which have the tendency to scandalize and undermine the dignity of the court and the majesty of law, amounts to criminal contempt of court. Paragraphs after paragraph I read last night. There are at least 7 or 8 paragraphs which completely fit into all these guidelines which your lordships have laid down. Let me read one more line, one more paragraph, paragraph 25. While a litigant, as also his lawyer, have the freedom of expression and liberty to project their case forcefully, it must be remembered that they must, while exercising that liberty, maintain decorum and order in the court proceedings. Liberty of free expression cannot be permitted to be treated as a license to make reckless imputations against the impartiality of the judges deciding the case. Even criticism of the judgment has to be dignified and temperate language without any malice. Your Lordship may see one more paragraph. My Lord, kindly see paragraph 28, only because this went from our High Court. Paragraph 28 at page 264. Lalit Mohan Das versus Advocate General Orissa. This court observed, Supreme Court says, my Lords, a member of the bar undoubtedly owes a duty to his client and must place before the court all that can fairly and reasonably be submitted on behalf of his client. He may even submit that a particular order is not correct and may ask for review of that order. At the same time, a member of the bar is an officer of the court, may not therefore locus, officer of the court, and owes a duty to the court in which he is appearing. He must uphold the dignity and the decorum of the court and must not do anything to bring the court into disrepute. The appellant before us has grossly overstepped the limits of propriety when he made imputations of partiality and unfairness against the munsif in open court. My Lord, here is by way of an affidavit. In suggesting that so-and-so followed no principle in his orders, appellant was adding insult to injury because the munsif had merely upheld an order of his predecessor on the preliminary point of jurisdiction and court fees, which order had been upheld by the High Court in revision. Now, my Lord, this line is important. Scandalizing the court in such a manner is really polluting the very fount of justice. Such conduct as the appellant indulged in is not a matter between an individual member of the bar and a member of the judicial service. It brought into disrepute the whole administration of justice. From the point of view, the conduct of the appellant was highly reprehensible. So in my humble submission, my lords, I will not write to read it again. I feel it, my lords, below the dignity of your lordships to read those paragraphs again. But in my humble submission, my lord, this is a fit case where your lordships will recall the order and issue proceedings for contempt against the petitioner. My lord, one more paragraph, my lord, here, and this is your lordship must have read several times. This is SP Gupte, that famous judge's case, my lords. SP Gupte, my lord, your lordship knows. This is that case where Justice Bhagwati says, what is the role of a lawyer? And I'm grateful to my learned friend who has filed this application, my lords. My lord, what he says is, what the Honorable Judge says is, the profession of lawyers is an essential and integral part of the judicial system. My lord, paragraph 26, I'm so sorry. Somebody will hand over the book to your lordships.
Necessary. I remember.
Yes, I am grateful. My lord, I am tempted to read it because I want all the members of the bar to have, I know your lordships know it.
But not resist my temptation.
I cannot resist my temptation because so many young friends are there, they must also know. There can be no doubt that the petitioners have a vital interest. This was in the context of the lawyer having locus, in the independence of judiciary. And if any constitutional or illegal action is taken by the state or any public authority that is an effect of impairing the independence of judiciary, the petitioners would certainly be interested in challenging the constitutional legality of such action. The profession of a lawyer is an essential and integral part of the judicial system, and the lawyers must figuratively be described as priests in the temple of justice. They assist the people in dispensing justice, and it can hardly be disputed. Without their help, it would be well nigh impossible for the court to administer justice. They are really and truly the officers of the court in their daily sit and practice. They have therefore a special interest in preserving the integrity and the independence of the judicial system. And if the integrity or independent judicial system is threatened by any act, they would naturally be concerned about it because they are equal partners with the judges in the administration of justice. They were saying whether just Iqbal Chagla had locus or not. This is a very unfortunate case. Let me tell you, Lordships, I joined the bar in 1984. In my 40 plus years of practice, I have never seen an application like this where scurrilous attacks are made against the court. It is not an individual judge I am concerned about it. But court as an institution, if we lawyers and your Lordships don't protect this institution, then where will you go? I may not necessarily agree with everything your Lordships are saying, but there is a process of judicial review. It is not to make scurrilous allegations against the court. And my lord, if your Lordships don't protect this institution, who will protect this institution?
That party is served.
Yes, my lord.
But served.
He has appeared. He is online. I believe he is online.
He is online?
Yes.
No. Yes.
My lord, may I please?
Yeah. Well, just before that, just taking over from where my learned senior is, just left. But this has become even more.
Two questions will arise.
Yes.
One is whether to recall that order.
Yes.
Which I have passed.
Yes.
Number two.
The recall only that part of where a leave has been granted to him to prosecute it otherwise. That part of the order has to be.
My humble submission will be, your Lordships will recall the whole order. Your Lordships have already kept it in, as already said that it will remain suspended. Your Lordships will recall the order, and the file will be restored to your Lordships. And my humble submission is, on the face of the allegations and the averments made in the writ petition, your Lordships, I would beseech your Lordships, to issue proceedings for contempt, because this is a clear case which is squarely covered by Section 3C of the Contempt of Court Act.
Yes, Mr. Mukherjee was saying something.
Yes, my lord. The role of the lawyer becomes all the more important because a judge is incapable of defending himself in a proceeding of this nature. And since this is becoming rampant by the day, even the courts are now very alive to the situations. And in the very recent past, the Honorable Supreme Court, in the case of N. Pedi Raju, your Lordship may see this judgment. I'll just read out a few paragraphs of the judgment. And I will also bring to your Lordships the latest judgment of the Bombay High Court, which has been delivered last week on this issue.
I'm supplying a copy of that.
Para 4, your Lordships, this particular judgment, your Lordships, first take para 4.
We had dismissed the transfer petition.
Yes, we had dismissed the transfer petition by the order dated 29th July 25. However, while dismissing the petition, taking into account the scandalous and scurrilous remarks made against the learned judge of the High Court, we had issued show cause notice not only to the alleged contemnant number 1, but also to Mr. Ritesh Patil, learned advocate on record, who had filed the petition, and Mr. Nitin Mishra, learned counsel, who had drawn the petition as to why an action for committing contempt of court should not be initiated against them. Your Lordships may thereafter skip over to para 11 at page 4.
Lord, read.
We have noticed, as your Lordships got that?
Para 11?
Yes, please. Page 4.
Yes, sir.
We have noticed that nowadays it has become a trend amongst lawyers to criticize the judges of the High Court or the trial court for no reason. It has also become a recurring trend.
Can I interrupt you?
Yes, please.
It has become a trend of lawyers, trend of a section of the lawyers. Because all you are here, you would not fit into that description.
How right your Lordships are.
lawyers. A small section of the
And they tarnish the entire fraternity in the process, my lords.
for spoiling milk. How much salt is required?
And problem is, my lord, the person who claims to be a lawyer is not a lawyer.
He is not a lawyer.
No, my lord.
No, he is,
He's enrolled as a lawyer, but
No.
at least
That enrollment number is given by him is found to be, my lord, forged.
It is not done now.
The entire story, my lords, that has triggered the cause of action for filing this writ application.
he is not a member of your bar.
No, my lord.
Is he a member of any bar in the country?
He is.
A bar council daily number was supplied, my lord.
Yes.
And on inquiry, it was found that that number belongs to one Gitanjali Sharma.
Not to this person,
My lord.
but in person.
My lord.
But other day when he argued that, he said he is a lawyer also,
Maybe.
and he is appearing in a slew of election petitions
That is the
as a
problem, my
lawyer.
lord.
And in this case, he was a petitioner himself.
Here is party in person.
No, that's what he said.
My lord.
I just remember. He is not a lawyer.
No, that is the reason why this writ application was filed. The honorable judge has directed for an inquiry and asked him to supply his correct enrollment number. He supplied it. And subsequently it was found upon inquiry that enrollment number belongs to some other person.
And this proceeding, the one which has been brought before your lordship, is a subterfuge to frustrate the proceeding which has been initiated.
That EP.
Yes.
May I please, my lord?
Inquiry.
That order was made when?
12-9.
Don't mention the name of judge.
No, my lord.
12-9, 12-9-25.
We all are.
We'll supply a copy of that order.
Just I want to just look it.
How you have
Just to see the conduct of the party. That's all. Because he is also here.
Your lordship may see this order. It's
Just read that order. Read. After all, it is an order of the court.
IA number so-and-so has been filed by Dr. Mahapatra, Subhash Mahapatra, who was representing the deceased election petitioner as lawyer, with a prayer to recall,
This has started the cause of action. এই অর্ডারে হচ্ছে আইএন
এই অর্ডারটা তো
May I please, my lord? May I please, my lord?
হ্যাঁ তো সেটাই পড়ি শুনে so-and-so. Sorry, Martin. IA number 98 of 25 has been filed. Condone that's not relevant. Para?
30.
Para 20, yes, ma'am. The application has been filed by the respondent number 1 on 23/12/24, seeking the following reliefs. 1, to direct Dr. Subhash Mahapatra, learned counsel to the election petition, to furnish his correct enrollment number along with the certificate of enrollment issued by the State Bar Council. 2, in case of failure to furnish the same, to restrain Dr. Mahapatra and any other lawyer appearing with his consent from representing the election petitioner in election petition number 29 of 24. To direct for investigation by CBI or any other investigating agency against Dr. Subhash Mahapatra on the allegation of committing fraud upon this court by appearing as an advocate by furnishing a false enrollment number. Para 2. As regards the first relief sought, it is noted that the same has already been allowed by this court by order dated 13/3/25. Paragraph number 13 and 14 of the said order are reproduced herein for reference. Para 13. Accordingly, this court directs Dr. Subhash Mahapatra to furnish his correct enrollment number along with certificate of enrollment issued by the concerned State Bar Council in his favor, supported with an affidavit on or before the next date of listing unfailingly, enabling this court to pass further orders in the said regard as prayed in the IA. Para 14. It is made clear that if this court finds that the allegation made in this IA is false, incorrect, appropriate order shall be passed against the deponent of this IA in accordance with law. Similarly, if Dr. Subhash Mahapatra fails to furnish his enrollment number along with certificate of enrollment or before the next date of listing, appropriate order will be passed on the adjourned date.
This was dated?
This order was passed on 13th. This quoted order, which I just read out, was passed on 13/3
25. And what I'm reading, my lord,
Pending EP number?
29 of 2024.
Yes.
Now, then the next paragraph there. In view of the demise of the election petitioner, the second prayer for restraining Dr. Mahapatra from appearing in the election petition has become infructuous. Fourth, so far as the third prayer seeking investigation, the same warrants adjudication in light of the report received from the Bar Council of Delhi and other materials on record. The record indicates that despite granting sufficient opportunity, no written objection was filed by Dr. Mahapatra to IA. Rather, on 13/3/25, Mr. Singh, learned counsel representing Dr. Mahapatra, orally objected to such allegations made in the IA on the ground that Dr. Subhash Mahapatra is an enrolled advocate having law degree, and any grievance regarding his genuineness of enrollment of Dr. Mahapatra as an advocate should be agitated before the concerned Bar Council in view of the specific remedies available under the Advocates Act 1961. Further, it is ascertained that this court-wide order dated 13/3/25 directed Dr. Subhash Mahapatra to furnish his correct enrollment number along with certificate of enrollment issued by the concerned State Bar Council in his favor, supported with an affidavit. But on 2/5/2025, Dr. Mahapatra submitted before this court that his enrollment number is D718 of 2001. And the certificate of enrollment has been lost somewhere, and he has applied for a duplicate copy of the same to the Bar Council of Delhi and is yet to receive the same. Accordingly, Dr. Mahapatra undertook to produce the attested copy of the enrollment certificate on 12/5/25. However, on 12/5/25, Dr. Mahapatra, instead of filing the attested copy of certificate of enrollment as undertaken, filed an affidavit enclosing thereto a letter dated nil, which was allegedly sent through speed post on 10/5/25 to Bar Council of Delhi for reissuance of certificate of enrollment along with a copy of the complaint made before the capital PS Bhubaneswar dated 8/5/25, stating therein that he had already applied for reissuance of the original certificate of enrollment to Bar Council of Delhi via speed post on 10/5/25, though on 2/5/25, Dr. Mahapatra submitted before this court that he had already applied for the same to the Bar Council of Delhi. Hence, while order dated 12/5/25, a report was called for by this court from the Bar Council of Delhi pertaining to details of the lawyer having been enrolled with the Bar Council of Delhi via enrollment number D718 of 2001. In response, the Bar Council of Delhi via communication dated 26/5/25 submitted a report wherein it was categorically stated, as per the records maintained by the Bar Council of Delhi, enrollment number 718 belongs to one Miss Gitanjali Sharma, daughter of Mr. R.S. Sharma, not to Dr. Subhash Mahapatra. To substantiate such report, relevant documents pertaining to her were also appended. Despite such communication made by the Bar Council of Delhi on 17/7/25, Dr. Mahapatra submitted before this court that the enrollment number 718/2001 belongs to him, and due to some technical glitch in the record maintained by the Bar Council of Delhi, such wrong information has been provided to the registry of this court. Thereafter only, on 17/7/25, Dr. Mahapatra filed IA number 19 of 2025 to recall order dated 12/5/25, pursuant to which a report has already been submitted by the Bar Council of Delhi. That apart, till date, Dr. Mahapatra failed to substantiate his stand that his enrollment number is D718 of 2001 belongs to him. At this juncture, the court deems
That may not be necessary.
Further, as per Section 2C3 of the Contempt of Courts Act, the term criminal contempt includes any act which interferes or tends to interfere with or obstructs or tends to obstruct the administration of justice in any other manner. Therefore, any individual who falsely represents himself, herself as an advocate and appears before the High Court would fall within the ambit of criminal contempt as contemplated under the said provision. In such a case, the High Court is empowered to initiate suo motu proceedings for criminal contempt under Section 15 of the Contempt of Courts Act, 1971. In addition to this, such conduct also attracts penal consequences under the Bharatiya Nyaya Sanhita 23. Specifically, it constitutes the offense of cheating by personation as defined at the Section 319 of the BNS, which is punishable with imprisonment for a term which may extend to 5 years, or with fine, or with both. Section 319 of the BNS is reproduced below for reference. Next para. On a careful consideration of the facts and materials on record, submissions made by parties, so also relevant provisions of law, this court is of the view that the allegations made in the IA are serious in nature, involving potential impersonation and misrepresentation before this court. The allegations, if found true, have the potential of undermining the dignity and sanctity of judicial proceedings. Despite being granted multiple opportunities, Dr. Subhash Mahapatra has failed to produce his enrollment certificate before this court. This persistent non-compliance casts serious doubts regarding the veracity of his claim of being a duly enrolled as an advocate. Furthermore, the report submitted by the Bar Council of Delhi also indicates that the enrollment number, so-and-so, which is being claimed by Dr. Mahapatra, is in fact registered in the name of Gitanjali Sharma. This discrepancy significantly amplifies the suspicion surrounding his claim of being an advocate and suggests a prima facie case of impersonation. However, as Dr. Mahapatra...
Why his original certificate was not asked? He had shown the original certificate.
He made a representation that it has been lost and he has lodged a police complaint for the same. And he made a submission before the court that he has already applied for a duplicate, which in fact on that date he had not. He made such an application at a later date.
But before the court he said that he had already
made. Well, this is a person who has been taking this judiciary for a right time and again. And now that he has been pushed against the wall, he wants to frustrate that by the present proceeding.
Yes, Nanda appears for the party.
No.
You appear.
Party is himself engaged to be an advocate. He doesn't. I don't think he requires any assistance from anyone.
Yes.
He's there in this. He's there in the.
He's there, but he's there.
Yes, sir. Party in person.
May I please, my lord?
Yes.
My lord, I have been got the summon on day before yesterday in the evening, and it's not the. It appears it's not the true copy. So there is no signature, nothing in the.
Let us copy if he's that concerned about the true copy of the application. It has been sent to him on email also.
Yes. Anyway, you are here now.
Yeah, my lord is in.
I issued notice to you.
Yes, my lord. Yes, my lord. I am an aware of the notice. I have received that, and that's why I am here, my lord. Because it was day before yesterday. I just arrived early in the morning, so I couldn't travel to Cuttack. So I am here. I will reply everything, my lord. It's a false and baseless allegations, and I need true copy of this because in case of Hindustan Construction versus Union of India, AIR 1967 SC 526, my lord. I need a true copy, exact copy what it is being there. Because what the copy I have right now with me received in the summons is nothing there. No signature, no attestation, nothing there. So once the copy is served on me exactly, so I will definitely answer everything, my lord. And further, I am trying to speak
the main petition which I have filed is something happened in the court.
Electronic application.
And that's why I requested the register of this Honorable High Court to preserve the CCTV. In the courtroom itself, I have been attacked by some unscrupulous element, my lord. So it was the reason I requested the concerned judge to protect me. And he abused with unparliamentary, filthy language, and it is there in the record.
My lord, I take serious objection to this language. Your lordships are holding a...
No.
Just one second.
Let me complete.
Please one second. But these kind of abuse to the court, my lord, lowers the dignity. This itself is contemptuous. Your lordship should not allow this at all. That's my humble submission for your lordship's kind consideration.
This was occurred, and the truth is truth. It was occurred. It was on CCTV. The people of this country see the proceedings of this honorable court, judicial temple of justice. So every people see what the people will feel who has believed in the constitution. I am a law-abiding citizen. I believe in constitution. Truth is truth, and it has been recorded in CCTV. Let the CCTV call for.
But how can I call for CCTV of my brother to respond?
No, when I am being attacked, and it's the principle of natural justice.
Please understand. Contempt aspect is one thing. The other aspect, when I did not have
misrepresentation,
the power to decide the matter on merits because of section 80 of the RPA. See that Mr. Parija said the entire order has to be recalled. That just show that petition. This petition has to go before the Honorable Chief Justice, perhaps.
Section 80.
I committed the mistake. I should have known the law. I should have fully perused the petition.
The bench always goes with most of the times
generally we go by
what the lawyer
said. He said that he is also a liar only, but he was appearing in
liar, yes.
I was under the impression that he is a lawyer.
He ought not to have made that statement before your lordship after the order was passed by this court wherein his identity as a lawyer has been doubted. That itself was a misrepresentation before your lordship of saying that he is a lawyer.
My lord, this incidents arise because the person who appears for the respondent number 1 who has a forged law degree. So that's why this is a vendetta. This is personal allegation against me. The person who claims as a lawyer who appeared for the respondent number 1, who became the senior advocate, he has no law degree. That law college doesn't exist at all. In the parliament.
Let
me complete. My senior should have patience. In the parliament, the law minister said, St. Mary Law College doesn't exist.
Second, you should not speak.
And the respondent number 1 in my case has no law degree. And I requested under Rule 11 of the designation of senior advocate Rule 2019 that this.
One second. You bring start. Okay. See, when Mr. Parija is arguing, you are saying that tone itself should not be used. They are all senior members of the bar. What is that you are saying against them? First, you may not agree with his submission, but there is a way you can't speak with the tongue dipped in acid that way. No, that I will not permit you. If you do that, I will stop you here only. Now you have to put on your. You have put off your yes.
I'm sorry.
I am sorry, my lord, because I am on the basis. I thought I couldn't be audible. So that's I raised my voice, but my computer is little technical things. So that's why it was the reason I issue my little tone higher. But it is not my intention to. He is our senior. I don't have any dispressed with anybody, a bar or any human society. I am a law-abiding citizen. I come from a Gandhian family, so I believe in non-violence and truth. So I respect everybody. I do not have any intention to hurt anyone. I'm sorry, my lord, but I thought it is not audible. That's why I speak little loudly. I withdraw this, and I should be provided the copy, true copy. I will reply, my lord, what happened. It is on the record.
You can see.
And my lord. Actually,
Yes, sir. First, you tender apology to senior advocates that you are not supposed to use that. Make your voice is not audible. You are ensuring that it is not audible to anybody. Your voice is not audible.
I withdraw my statement, my lord. I apologize for this. I apologize for this.
It is like George Bernard Shaw withdrawing statement that 50% of the parliament members are donkeys. He said 50% of the parliament members are not donkeys. I will not permit.
I'm sorry, my lord. I apologize, my lord. I'm deeply regret this.
Then you will have right of audience in the court. You cannot use rude language in this court. This is a court hall. You are not in the marketplace of Cuttack, where you can see anything to anybody. That is not the way the court proceedings are conducted. First you offer apology to your learned counsel, Mr. Pariza, Mukherjee, Nanda. You are not supposed to find the other person. You said he does not have degree at all. You are not the university to say whether he is having degree, he is not having degree. But bar counsel, we can verify whether you are a lawyer or not. Yes. What is that you are speaking? First you tender apology to them. Then you will have right of audience, not otherwise.
I apologize, my lord. And I don't have an intention to hurt anyone. I regret for this.
You apologize to whom?
To everybody in the bar and this honorable court also, my lord. So everybody, every human society, I apologize for this. It is not my intention to hurt anyone. It is not my intention to hurt anyone. I come from a Gandhian family. I believe in non-violence and truth. So
I do not know. I don't read your horoscope. Kindly understand this. First, we do not want your apology in rem. Court expects your apology in personam. Tender apology to Mr. Pariza. Tender apology to Mr. Mukherjee. Tender apology to the advocate whose name we have taken. He may not be here at all. I do not know. Tender that apology. Then you will have right.
I apologize, my lord. I apologize everybody in presence in this honorable court, including the senior, my senior Sarji and other. I don't recall the name, and everybody I apologize for this, but
not their name at all. They are all unknown people.
Definitely, my lord. Not a practitioner. No.
Anyway, sir, they have tendered unconditional apology to all of you. Okay. Now we will speak slowly. You appear to be express railway driver. Be little slow, because I have to understand. I am not that sharp. Kindly go. Let there be some comma, semicolon, full stop. Then I can understand. Otherwise, I am not. I am not that capable. Kindly, you have to bear with me.
My lord, the writ petition 24143 I have filed. It is, I don't know what is the reason it is placed before your lordship, my lord. It is supposed to be.
You have sent with the notice. Sir, with the copy of the application.
Yes, my lord.
Yes.
Let me complete, my lord. Let me complete. The writ petition I have filed 24143 by 2025. It is supposed to be listed before the Chief Justice, because in the cost title itself, I have read that I have filed this writ application under section 80A of the Representation of People's Act. It is
somebody to control you.
no,
No, because I control you.
my lord, it is the
At least 1 second. Now you are saying the writ petition ought to have been posted before the Honorable Chief Justice. You are very fair in that. You are very fair in that. I appreciate. It is because section
80A of the Representation of People's Act.
1 second. Halt now. We'll go one by one. Section 80.
80A.
80 capital A.
Yeah.
or 80 capital A?
80 hyphen capital A.
The High Court having jurisdiction to try an election petition shall be the High Court. The court has jurisdiction. Such jurisdiction shall be exercised ordinarily by a single judge of the High Court, and the Chief Justice shall then assign one or more judges for that purpose. So, in terms of this, what Mr. Parija says appears to be true. I have to recall this entire order. Mr. Mukherjee, entire order needs to be, Mr. Parija is right in saying, the entire order. Once I do not have power, I cannot grant liberty.
Yes.
Because of granting liberty partakes the character of an order on merits. It borders merits at least. Therefore, as the petitioner party in person is saying, now that I will recall this order.
My lord, I have something more to say, if your lordships don't mind, my lords.
I can hear you also. That anyway, very well.
Yes. Well, so my lord, not only will your lordships withdraw the order,
yes,
but your lordship should also take judicial notice, my lords, of the allegations made in the petition against your lordship's court. And if your lordships are satisfied that such allegations are covered under the Criminal Act, Section 3C, your lordships will issue suo motu contempt proceedings against the petitioner, lords. What my learned friend is saying, that he is surprised as to how this petition was listed before your lordships. In all fairness, my lord, your lordship should have been told on 9th of September 2025 that, my lord, this matter has been wrongly listed. It should go to the appropriate bench. But when I read this order, it says, learned counsel for the petitioner party in person, having argued the matter for some time, he never told your lordships that this is a matter which has been listed in the wrong court. Seeks leave of this court to withdraw the petition with liberty to pursue the remedies elsewhere in accordance with law. My lord, any counsel would have told your lordships, my lord, this is a matter to be listed, which is not in your lordship's roster. It will be listed before the Honorable Chief Justice. He doesn't say anything. So look at the conduct. Will your lordships allow such practice? Lord, it is our endeavor to bring it to the kind notice of your lordships, because my lord, this is something very serious. This is something very serious. Only after the contempt proceedings are over, thereafter maybe the file will go to the appropriate, to the Honorable Chief Justice for whatever reliefs he can be granted in that court. I don't know. Because once your lordships have already appointed, once the Honorable Chief Justice has already entrusted exercises
or more judges.
My lord, may I recall, my lord,
Mr. Mahapatra, just half a second. Once, my lord, the Chief Justice has already exercised his power under Section 80A, and my lords, a proceeding is going on. If such practices are allowed, then every day, every petitioner who is not happy with the proceedings will come and say they transfer the case to some other judge. My lord, these are not matters, my lord, between me and Mr. Mahapatra. These are matters for your lordship's court, your lordship's conscience, and your lordships to uphold the majesty of the court. That's all we are saying. I have nothing against Mr. Mahapatra.
No, he is entitled to take all defenses in the event the criminal proceedings are initiated.
Absolutely. Of course, my lords. Even the Bombay blast victims were given all the protections as available in the rule of law. We believe in rule of law. My learned friend will have all defenses to take.
Now, under your rules.
Our rules also say that criminal contempt petitions are to be decided by division benches. But before doing that, your lordship
benches not less than 2 judges.
Yes, but to do that, your lordship has to prima facie frame the question and refer it to the court as to whether the criminal contempt proceeding, because prima facie your lordship has to find that yes, this is a case where the criminal contempt proceeding has to be initiated. And your lordship will make such an order and refer the matter through the Chief Justice to a division bench where the proceedings can. He will be served with a show cause notice and he has to respond to that.
My lord, may I please, my lord? This IA, I received the notice on day before yesterday in the evening, and this is not the true copy as appears to me. So I need a true copy to file my response, and this is the principle of natural justice. After that, I will reply. Who is this? This is not the. This is a election. This is a writ petition. Between respondents are there, and some I don't know who is the IA applicant. And he claims as a lawyer, but there is no identity disclosure itself as it appears from the notice. So let me file the response, my lord, pass on any order, my lord. This is my lord's wisdom, but let me file the response. A day before yesterday, I have received this summon, and as per the Odisha High Court rules, chapter 624, I read, my lord.
Yes.
No affidavit shall be read at the hearing of any appeal, application or other proceeding, unless a copy thereof has been served upon the other party or his advocate at least 7 days before the hearing. So day before yesterday, I got the notice, summon. At least allow me the time, providing the true copy, my lord. In the Hindustan Constitution's version of India, the definition is there. What is the true copy? How it is being solved? The duly procedure has to be followed. And provide, my lord, I should be served a true copy. Who is the plaintiff is being presented before, my lord? So after that, I will have the time to file the reply. This is the principle of natural justice.
The one which is now served on you is the true copy, whether it bears signature or not.
No signature, nothing, my lord.
Need not be, because that is sent to you now. You treat that as the true copy, because I have seen you can look into everything in the online facility itself.
My lord, I have to go to the court and see. It is the principle of natural justice that should get a true copy. It is in the Hindustan Construction version of India, and Radhika Murasa versus Roop Singh. So it is there, my lord. They should provide a copy at least. It's the principle of natural justice. There are lots of allegations against me by many senior persons here. So I
am not deciding on your allegations, etc. What I will say is, this order, I have committed mistake by passing this order because I did not have the roster. The power is only with the Honorable Chief Justice.
My lord, may I recall, I particularly section 80 read on that particular day, my lord. It is not that I have suppressed the fact. I read, my lord, on that particular day, section 80.
One second. Mr. Mahapatra, you have to listen, at least to give an opportunity of hearing to the judge. Or you don't want to give. You tell me that.
My lord, I folded hands, I pray, my lord.
Therefore, you are
I respect the wisdom of every person, my lord.
Very good. Now, be kind to the judge also. Give an opportunity of hearing. Now I am telling you, I should not have passed this order without looking into section 80 capital A, I assume that you told it to me that I have no power. No, 80 is staring at me, 80 capital A. I have to recall this order as rightly submitted by Mr. Parija. Now you only said, now you said that you told me that I don't have jurisdiction, though I don't remember. Now I believe you. I'll recall that order. It's your case that I don't have jurisdiction.
My lord.
I am not the allegations, counter allegations, etc. I will recall this order and I will post this matter before Honorable, before the roster judge. It has to be before the Honorable Chief Justice only, because section says that.
My lord,
Yes.
even this IA on the basis of this
No,
IA.
not on the basis of IA, suo moto. This is only information is brought before me by this application. I am not acting upon the application, but the facts which I am seeing, that I did not have jurisdiction at all. Merely because it is application is moved. It is not that I am making order on the basis of the application. If somebody brings to the notice of the court, or court suo moto comes to know that it should not have made that order, in all fairness to the parliament, at least to the parliament, in terms of section capital 80A, I have to recall this order. This is what Mr. Parija is saying. Number one. Therefore, you should permit me, kindly you have to permit me to recall that order. Because it is your submission. I don't have power. You said that you had said it, told me that day also, though although I don't remember. I don't deny that. I will go by your version now.
This petition is not election petition. That is
I will accept your contention now.
My lord,
For me to accept it.
it's your lordship's wisdom, my lord. So
No, if you think that I am little wise, then I will understand you. You said you have no power, and you said you told this other day also to me. Maybe that you have told, I don't know. I don't know. But I appreciate you if you had told that. Anyway, I appreciate you. Today also you are sticking to the same stand, that this court had no power to pass the order. That's really appreciable. Therefore, I will recall this order and place the papers at the hands of Honorable the Chief Justice. Because section 80 capital A says it, as you rightly said now. Kindly read section 80 capital A. I will provide that 80A to you, because perhaps you have not brought the book also.
it is there, my lord. I am aware of the law, my lord. It is 80A, and it's the time to time it is the authority of the Chief Justice to assign the judge.
80 capital A.
Yes, my lord.
80 capital A. I appreciate you that you said that I did not have power. Perhaps I should have been impressed by that. There is error on my part also now.
My lord, your lordships are being very kind.
Anyway, he himself said two things he said. One, he tendered unconditional apology to all of you. To you. Not to the court or the judge against whom he made allegation. That is not our concern. I will place this matter before Honorable Chief Justice. And he fairly said this court has no power to pass the order. If that is so, I could not have granted liberty at all. Because granting liberty, whether to grant or not, it borders the merits. There are such decisions. And I feel Mukherjee perhaps will also now agree, after hearing Mr. Parija, that the entire order has to be recorded. That order I am recalling. This is number one. Some arguments are made that there is a prima facie blatant case of contempt, criminal contempt of the court. That I will treat in my wisdom this way or that. But under your rules, which I had an opportunity of going through your rules before I came to Orissa. Under your rules, it says it not less than 2 judges of the High Court. I think there is such a rule. Can anybody pull out that rule?
May I please, my lord?
Yeah. Kindly read. Now we'll go by your version.
Rule 7, rules to regulate content proceeding, my lord. The all proceeding under this act in respect of criminal contempt only shall be heard by a division bench of the court. It's Rule 7, my lord. Rules of Orissa High Court 1948, my lord.
Rule 1948, page number, Rule 7.
Rule 7, Chapter XVII.
Yes.
Rules of the High Court of Orissa 1948. Rule 7. Rule 7 of Chapter XVII. Rules. Rule 7, Part 1, Chapter XVII.
Legislature of the rules. Mr. Parija.
Yes, my lord.
Nowadays, we judges have become little thick-skinned. More thick-skinned than about 20-30 years ago. But the allegations just I went through, they are egregious, very demeaning. Whether truth is a defense or not, I need not tell you.
Correct.
Defense in defamation, this is what the standard books like Winfield and Todd, Bangia, all the standard or Ratan Lal, they say like that. Anyway, there are judgments. There is one judgment of the Apex Court in GL Gaba versus Swine to 1950s court that truth is not a defense to the contempt of the court. But truth started with the frill is a defense under some provision of 1971 Act. I have read some judgments like that, including one EMS Nambudri Pad versus Swine. So, but there are prima facie very, very unhappy the pleadings which the party person. I don't say that he's liar, he's not a liar because I do not know. And that is not the domain of my adjudication also. Now I am convinced I don't have jurisdiction. I am convinced of the argument of Mr. Party in person. Mr. Mahapatra is right in telling the law that I do not have power. I have to respect him. So I will send this matter, I will recall that order and send that matter before the Honorable Chief Justice to treat it under Section 80 capital A with the observation that the certain averments taken in the petition or have the elements of contempt, elements of criminal contempt, but I will not take action.
No, Your Lordship may just...
My lord, I bow down to Your Lordship's wisdom, my lords.
Yes.
Your Lordship may only note the submissions made by me and my Mr. friend, Mr. Mukherjee, my lords.
So argued that, and he should also have opportunity before the court. The other court, if at all, the other court decides to issue, not to issue, is entitled to opportunity of principles of natural justice, which he vociferously rightly said. Therefore, I will recall this order in a wholesale way, and I should not have made this order at all because I have no power. And the allegations, I will not reproduce them because I don't want to reproduce them. Because Mr. Parija said I don't want to read them also. I also feel I should not reproduce them. Whole petition will go before the Honorable Chief Justice, and in his wisdom, his Lordship will decide the matter.
My lord, may I say one line, my lords?
Yes.
Your Lordships were not wrong because 80 cannot control 80 capital A does not control Article 226.
Correct.
It is just that your Lordships think in the fitness of things to place it before the Honorable Chief Justice. But that is not. But that is not to say, my lord. I am saying your lordship is recall.
At fault because I tell you.
No, your lordships are not at all at fault. That's the point I'm trying to make. My lord, I'm not saying that your lordship should not send it to the Honorable Chief Justice, but your lordships were treating an application under Article 226, my lords. Basic structure itself says that ATA cannot bar your lordship's jurisdiction. Whether your lordship will exercise that jurisdiction or not is another matter.
That's true. But the mistake lies on the part of this court, on my part, on my head.
Mistake, my lord, I am little bothered about the expression mistake your lordships are saying and again.
Ex debito justitiae is a mistake of the courtroom.
No. My lord, with great respect, and all humility, this mistake is not a mistake, my lord.
He should tell it that I am wrong. What is that? My respect.
Let me put it like this. There are two views available. Your lordships took one view.
Anyway, you are very kind to me.
No, my lord, we are all a part of this great institution.
That's
Lord, I have been here more than 43 years now, my lord.
One question. This bar is known for sobriety. I swear and tell this. This bar is tall, known for sobriety. Nobody raises any objectionable things in the court hall. Nobody does that. But this is one glaring exception which I have come across.
It's not from the bar.
I tell the truth. It's a glaring exception. Beyond this, I will not say.
That is the pain, Maharaj. It is being represented that this also has come from the bar. What needs to be unraveled is
that it is from the bar at all.
It is not from the bar. That is what is required to be unraveled. And that is what is sought to be frustrated by filing this application under 226.
Anyway, I will not make any further comment on that because party will be entitled to have his say before the jurisdictional court. Take note. The case in WPC number 24143 of 2025 was disposed of by this court, wide order dated 9/9/2025, ex parte, the OPs, ex parte, the OPs at the admission stage. First one, the short order is reproduced for ease of reference. Next paragraph. Now, the applications have been moved in IA numbers 16218 of 2025 and IA number 16219 of 2025, essentially seeking recall of the said order. First, the applicants are not parties to the writ petition. Correct? Applicants are not parties to the writ petition. First, this court is not very sure whether the applicants have any locus standi to move the subject applications. Be that as it may. The applications reveal that this court did not have, this court ought not to have passed the order of the kind, especially granting liberty to the petitioner to agitate his grievance elsewhere, when the matter did not fall within court's roster as prepared and published by the Honorable Chief Justice, who happens to be the master of the roster, while the apex court decision in state of Rajasthan versus so-and-so, which is that judgment 96-97 Supreme Court, where it said Only the High Court Chief Justice alone will allot the matters. First. Next paragraph. Party in person who also claims to be an advocate, rightly submits that in terms of section 80 capital A, the matter should go to the hands of Honorable the Chief Justice. First off, he thrice said in the course of hearing today that this was brought to my notice on the first day when the writ petition was heard. First off, heard. Next paragraph. In the above circumstances, the subject order is liable to be recalled, and the matter has to be placed at the hands of Honorable the Chief Justice. First off. Next paragraph. The above being said, learned senior advocates Shri Parija, Mukherjee and Nanda very vehemently submitted that the averments in the writ petition amount to prima facie amount to gross contempt and criminal contempt of this court, and therefore action should be initiated against the petitioner party in person. First off, a perusal of the contents of the petition prima facie show that scurrilous allegations are made against a learned coordinate judge of this court, and on that ground, transfer of EP number 29 of 2024 was sought for.
My lord, election petition number 30.
And first time. However,
my lord, it's election petition number
under rule, however, Mr. Mahapatra, Dr. Mahapatra,
my lord, it's election petition number 30.
13 of 2024.
3024. It's not 29.
24. Next part. Mr. Mahapatra draws attention of the court to Rule 7 of
Chapter 17.
Rule 7 of Chapter 17
of the Orissa High Court.
Orissa High Court rules, which vests exclusive power to deal with contempt matters. Criminal contempt of the case, the court. Criminal contempt of the court. First, more is not necessary to specify. Next paragraph. In the above circumstances, this court suo motu recalls the order dated 9/9/2025 in a wholesale way. And as a consequence, the writ petition in its present form and substance would stand revived and restored to the board for consideration afresh at the consideration afresh. First one, registry to post it before the roster bench. This is the general pattern of my order. Little this side, that side, linguistic upholstery would be done to that. If anybody wants to say anything, that also I will keep in mind.
Your Lordship.
Right?
That's
Okay.
Lord, we are extremely grateful to your Lordship, my Lord, for a very patient hearing.
No, in matters like this, really, I should tell one thing. I really should tell one thing. We judges work under tremendous pressure. By the time we go home, nothing is left in us. Really. And we do with absolute commitment, because nobody comes to court happily. And we go home very late. We come to court very early. We go home very late. The judges and our staff of the judges, like stenos, PSs, even they work under tremendous pressure. And most of them have got BP, sugar, very natural. These are occupational hazards of this
Profession.
court profession. For you also, perhaps. I understand that. When some allegations are made that this judge is not a good judge, his language is not good, his behavior is not good, he writes the judgments with pen dipped in acid. These things we very easily digest, and they do not, unless we hear them, we will not be happy at all. We want such allegations day in and day out to show that we are alive to ourselves. But when very wild allegations are made, that hurts not only the judge against whom it is made, they are made, but other judges also. Because if you make allegation against one judge,
it undermines the entire institution.
Entire institution is one thing. What we have seen, especially our High Court and Supreme, even district judiciary, courts still enjoy confidence of the people, because they have been delivering the goods and services to the satisfaction. Courts have saved democracy in this country. I am just saying what Mr. Nariman has said, Sirwai has said. I am just saying. Granville Williams has said in his two books, The Indian Constitution, a cornerstone of the great nation, and working of a democratic constitution. Dr. Upendra Bakshi has said this. Courts have saved the constitution and the basic features, basic structure, everything. What is this? What are these courts? Are they buildings? Courts are nothing but the judges. If one judge is scurrilously attacked, what kind of message it sends to the other judges? We will show withdrawal symptoms. We start defense mode. We go to the defense mode. Why at all we should take all responsibility? Why we should antagonize the government? Why we should antagonize the establishment? Let us pass consideration. Consider the representation. But that will not do justice. It is duty of the bar to protect the dignity of the court. Similarly, it is the duty of the bench to protect the dignity and tallness of the bar. It is not that empty slogan, bar and the bench are two wheels of the chariot. They are not two wheels. The whole chariot is on one wheel. One part is one side is bar, another side is bench. Without you, we cannot do anything. Therefore, ensure that your judges remain with the spine, their spine is not broken. It is in your interest because we decide the rights of people, the status, spousal status, marital status.
That is exactly where the locus comes in.
Everything.
Present applications.
Therefore, we may err. If we err, you have many remedies. Appeal is there, review is there, revision, whatever remedy you can take. But kindly, do not attack the judges personally because you will be getting gangrene in your parts. Because your court is your part only. It is not privy council on the other side of the sea. It is your court. Therefore, I very humbly request you, don't make allegations against the members of the judiciary. Do not be. Where we should ventilate our grievances if they are made. Therefore, protect the judiciary, protect the judges. If they err, go to their chamber, go to their house and advise them. They are not all members. Sir, it has happened like this, it should not happen. Even that in any function, etc., when you meet, you can advise people. In fact, more
like to seriously introspect.
Yes. But don't make wild allegations against the judges, which are not true. Which are not true, I tell you. If at all you have grievance, you can put it in a sealed cover. Send it to the concerned. Why you want to put in everything in public domain? What is your right to defame the courts, defame the judges? If you have any grievance, put it in a sealed cover, send it to the concerned. You have every right to do that. But you're giving in public domain, making all allegations in the public domain, what the judge should do. Anyway, now this is...
Milord, would your lordship's mind half a minute to me?
And
would your lordship give me half a minute, minutes?
Yes, yes.
I have been greatly enriched by your lordship's wisdom. I only respectfully request Mr. Mahapatra that he should seriously introspect about what your lordships have said, milords. Because ultimately, Mr. Mahapatra also owes something to our great institution. That's all, milords.
Do you want to say anything? In response, do you feel that what it's done is not in good taste?
My lord, with sincere, first I should make sincere re-apology to all of the members presented there. I am man of this state and I apologize for everyone for my things. And I also respect Parija sir and everybody there. My humble things that some unwanted things happened. So if all the members, most Syrian members are there, I can meet them. If they may permit, we can amicably discuss all this matter without the court going into legal aspects, my lord. So we can, if they permit, I don't have any objection to go into that way because we are all in human super society. We have, none of us are perfect. So
now discussion is not that proposal is not acceptable to. What is that discussion between the attacker and the victim? There is no discussion. Question is, if you unconditionally tender the apology, I will record that also. I will send the papers to the Honorable Chief Justice. Apology to the members, apology to the judge. I leave it to you. It is your prerogative. You are entitled to all contentions. I also say...
My lord, I regret for this statement. I unconditionally apologize for this, but matter be...
Unconditionally tender apology to the judge.
Everybody, my lord, it's not...
Milord, not to the lawyers, to the honorable institution. Let him render his unconditional apology to my lord, to the honorable judge, and that the lordship may record. It will be in his interest ultimately.
My lord, I re-applies to the respectable honorable judge, my lord. I don't have any aggression against him or anyone else, my lord.
You are not answering the point.
Yes, my lord. I applies to the concerned honorable judge, my lord,
Yes.
for my wordings and my pleadings.
Yes.
Let him put it on affidavit.
Yeah. You file an affidavit.
Yes, my lord. Yes, my lord.
Unconditional apology, etc.
Yes, my lord. Yes, my lord. Yes, my lord. I will put an affidavit.
Unconditional apology to the court, to the members of the bar, because they are also part of the court.
Yes, this is the holy institution, my lord. And if we lose this institution, then we will be no here in the democratic country, my lord. It is democratic setup. I understand the concern of these honorable members who are present here. I also respect the concerns raised by your lordship, my lord. So he is the presiding officer, my lord. So I respect him, my lords, my lords. And I also regret for my wordings. I regret my wording and my pleading, my lord.
Myself, he is one of the finest judges of this court. See, his judgments are taken in appeal. Even Lord Lenning's judgments are taken in appeal, and they are reversed by the House of Law. That's another thing. Now, if you agree to tender unconditional apology,
I have already tendered my unconditional apology, my lord. Yes, my lord, I will file the affidavit, my lord. I undertake, my lord, I will file the affidavit.
Number 2, you should withdraw all those allegations which you have made in your petition. You should withdraw those allegations unconditionally. If you do that, well and good. Otherwise, this order will remain.
No, my lord, I will file the affidavit seeking the withdrawal of these allegations, my lord. It's not. I respect, my lord. I respect the wisdom of my lord. I respect my lord. I understand my lord's concern. Nobody is perfect in this human society. This is in my pleading. There are some words I should not have used. I unconditionally.
What allegations you have made, great judge? Who will pardon you? At least wisdom has dawned on you. That's good. You file unconditional apology, and we will direct that apology to be published in 1 or 2 newspapers. Because now all people have seen this. All people have read your petition. What should happen to the judge? Therefore, you file affidavit, and that should be published. Your apology should be published in the newspaper. Otherwise, tomorrow everybody will make allegation and go away after tendering the apology. That should be published in the newspaper. If you agree.
But to be fair to Mr. Mahapatra, he has agreed to file an unconditional apology. Well, let him file an affidavit, and then the lordship will dispose of the matter.
At this stage, Mr. Mahapatra, petitioner in person, tendered unconditional apology to the learned judge of this court, against whom highly egregious allegations were made. Egregious and scurrilous allegations were made. And to senior advocates, Mr. Parija, Mr. Mukherjee, Mr. Nanda, and which other member you said? And all other members of the bar for taking up, making the said allegations against the judge. First off, he also agreed. He also undertook. Should I say agreed or undertook?
My lord, it's my lord's wisdom. I said undertook. I will file the affidavit. Madam.
Repeatedly submits that he would file an affidavit tendering unconditional apology and also withdraw all allegations made against the judge concerned. Tomorrow. Yes, and tomorrow you should file an affidavit.
My lord, tomorrow is Saturday, so can you make it Monday, my lord?
Monday, all right.
It is tomorrow Saturday, my lord. So it's
Court is there.
Yeah, court.
Let it be Monday.
Call this matter. With this proposal, the all members of the bar are agreeable. First, call this matter for further hearing on Monday evening. First, Mr. Mahapatra shall be personally present before the court on the next date of hearing, on the said date of hearing. Kindly come to the court.
yes, ma'am. Yes, ma'am.
Thank you, everyone.
Grateful, dear lordships.
This is draft of the order. Little linguistic change it undergoes. Okay. Yes, sir.
Item 26.
My lord, may I have your lordship leave, my lords, to go?
Yes.
After such a matter.
Yeah, it should not happen. He's one of the tall members of the bench.
Yes, no doubt about it. May I just, this matter, my lord, may I just tell your lordships the brief outline of the matter which be considered by your lordships?
Yeah. Ready?
Yes, my lord.
Yes.
But this relates to.
Can I
as your lordship,
can we come back at 2 o'clock?
Yeah, 2 o'clock. Your lordships have a bench. Some matters are there.
Correct.
Probably it may not take some time, but I'm checking up 2-3 matters.
2-3 matters.
I will get thereafter.
Thereafter,
I'll be here.
I'm coming.
Yes, yeah. Grateful, sir.
Okay. Yes, sir. Yes.
Yes. Now the atmosphere is very cool. So
Yes, sir.
Lord, I'll just give your lordships the outline.
There should be. In fact, I do not like piece of the grave.
Yes.
There should be some.
Yeah, that piece of the grave is absolutely unacceptable. Yes. But the petitioner, I'll just give your lordship before going to list of dates and other things, the brief outline.
Yes.
But the petitioner before lordships is a company. The company which has the charge-chrome factory in the outskirts of Cuttack. I mean, near the Mahanadi River, in the charge-chrome factory, it has also a captive power plant. It has a charge-chrome factory, it has a captive power plant. For this purpose, they require water, and the source is government. Government has 2 sources. My lord, the rates are different. If it's an irrigation source, then there's a definition what is an irrigation source, then the rates are higher. If it's a government source, that means normal river water, then it's also chargeable for an industry, but the rates are lower. There are 2 sources, government sources, irrigation sources. There's no free water.
Water is chargeable.
Then it's all chargeable. There's no dispute on that.
Yeah.
It's a question of rates and whether that is. But what happened, my lord, we had what they have a 3-year agreement period for which whatever water we require, we have an agreement with the with the Water Resources Department of the state, and they say that this is the period for which you are chargeable. But in 2012, there is that particular factory has the advantage of it has two sides. There are two river sides. Like one is a small river, it's called Birupa. Just for the name part, it's all in the name. The other is the main Mahanadi river, which flows here. One side is the Mahanadi, the other side is Birupa. There are two water sources which can, but originally we had Birupa water sources.
Birupa is B-I-R-U-P-A.
B-I-R-U-P-A.
Is it Samskrita Virupa? Virupaksha. Virupaksha.
So, my lord, is there in the, my lord, I'll just, because they're all in the list of dates and notes. So, yes.
Understood.
Yes, but in 2014, Lord, because 2012 we had taking these water resources from Birupa, which is an irrigation source. We had a requirement of water more. I'll tell you, Lordships, thereafter it was reduced, the requirement. So, on the advice, but there's no written thing, that the Mahanadi side is a government source, not an irrigation source. So, we changed from, we took 7 kilometers of land, 7 kilometers of laying pipes and other things, and took from the Mahanadi side, only on the ground that it is a government source. And if you also ask me that if anybody written to you that is a source, and no. The answer is no. We changed to the Mahanadi side because it will be a government source. That means the rates will be different. Our agreement was almost 10 Q6. That's the term they use for water, 10 Q6 plus
a huge amount
because for the factory and the complexes and for the. But this was till 2014, we had an agreement to take from Mahanadi side, the Lordship can note it down mentally that it's a government source. Admittedly, according to them, it was a government source. So we took government source 2014.
Yes.
More than 10 Q6 water. But 2015.
Yes.
At this 2015, what happened? Because of the coal deallocation by the orders of the Supreme Court, this is Lodha's judgment, the coal deallocation, we had been allotted a coal which was deallocated because of the matter into auction and all that. Our requirement came down. That means we did not have the requirement of 10 Q6 of water. We wrote to them, we need the exact amounts I've given. I'm just giving a lots of broad outline. Lesser 6 Q6. We said to them in 2015, that we want less. That means 6 Q6 of water. And that's the what we are consuming much less than that. We want 6 Q6. That 2015.
Is there any meter which measures?
If there is a meter, that means if you have an agreement, if you have a meter, whatever is more is chargeable. And there is a meter also. There is a flow meter as per the Act, there is a meter. So 2015, when you gave me lot, the engineer in chief recommended to the government that we have applied, that means our company has applied for reduction, and he recommended that it may be reduced. But immediately in 2015, he recommended that it may be reduced.
Yes. Because you do not need it.
You don't need it.
And fortuitous because of the apex court
judgment. Because of the apex court judgment, coal deallocation, I don't need it, so in 2015. But 2015 to 2016, for whatever reasons, I'm not giving any other reason, but in fact that it continued. I pursued, but they never allowed me till 2017. That was the period of agreement was coming to last. 14, from 14, I applied in 15. They agreed, agreement not the authority, not the government, but the engineer-in-chief recommended. But it continued for 2 years without reduction and continued until 2017. But 2017...
But you actually consumed
less. That is there on record. There's no doubt on that. I consumed less.
It's a question of meter.
It's a meter, meter reading is consumed less. But when in 2017, it is consumed, but thereafter, just before the agreement was to lapse, Lord, when the government said, government authority said, you come down to have the reduced agreement. I went for the reduced agreement. Last moment, they resigned from it and said, no, we want to revisit the matter. So we are not allowed to Well, I'll tell you, it's very interesting. But they said to come for the agreement, other things on a reduced quantity, but they again withdrew and resigned from it and said that, no, you continue with it. We will examine what is your requirement of water. We will examine what is your requirement of water. You get records from IDCO, other authorities, for whatever reasons, your lordship. These are reasons I cannot explain. They reside. So 2017, Lord, because water, unless I signed the agreement, under protest, I signed again for the same self quantity of 10 cusecs that the maximum quantity was taken. I was constrained because without that, I will not get water. I signed it under protest saying that subject to my reduction.
You registered a protest also?
Yes. That's on record. I registered protest that you signed. But 2017, thereafter, my lord, I was constrained and I approached the High Court in an earlier writ petition, saying that they're not reducing. After I approached the High Court, my lord, what happened? After the writ petition filed, notice and others were exchanged, these two have given the reference of two. Then thereafter, my lord, they asked me to come forward and sign the reduced agreement. That means 2018, they asked me and said the reduced agreement, that means the quantity which I wanted, they allowed, but allowed in 18. That means they are charged from 15 to 18.
15 to 18 full charge.
Full charge. Because they did not allow me.
The grievance.
That is the first grievance, Lord. That's the second grievance also. I'll tell you, Lord. The same one. That's the main grievance, 18. Then, my Lord, when the writ was there, so when I came to the High Court, said that you make a representation for refund. I asked for a refund. The refund was rejected on the ground that there was an agreement period, so we can't allow you a refund. There was a first agreement 14, 17, forced to agreement 17, and finally they made a revised agreement in 18. So since you have an agreement period, we cannot allow you to reduce it because your agreement was for 10K. That's the first part. But while this 2018, 19, and they are not reduced and are there, but what happened? The audit objected that the river, the water from which I am taking is not a government source, but irrigation source.
That's the view of the audit party.
That's the view of a audit.
Constitutional audit.
It's a principal AG of the state. CAG. Yeah. But they came and objected that no, this is the water. In fact, the government stated before them that government view was that it's a government source. Because as you Lord said, difficult certainly for me to also explain, because embankment from this side to that side, if it is within the water which is within, then it is enclosed bund water, it's a irrigation source. If it is not, I mean, every water in Mahanadi has an embankment somewhere. I mean, maybe out of 50 kilometers, maybe out 30 kilometers, but every embankment will not be considered irrigation. So they have some technicalities, my lord. I'm not on the technicalities part now, that whether it's irrigation or not irrigation. But I'll tell you, lordships, my lord, then what happened was, and then what happened, my lord? The government said that now you have to pay and the rate of irrigation starting from your beginning,
2014. Up to 2018.
From 18 plus 20, finally they made a revised agreement in 20. They made a revised agreement on 20.
Under protest you did it.
No, in 20 they made a revised agreement on the basis of irrigation.
They reduced it.
Because
in the 20 they reduced it.
No, reduced. It's on irrigation, as irrigation. So what I'm simply submitting to lordships, one side, I say I don't require the water from 15, and you recommend my case and keep it pending till 18.
17.
Till 18 finally. Finally, the 17 also they did not allow. In 18 they allowed. 3 years, you're charging me 5 crores for that. Now you are asking me on the ground, and you didn't allow me on the ground that there's already an agreement. But on the same footing, you already had an agreement with me for government sources from 14. But you yourself force me to pay from 2014 in the rate of irrigation from 14 backwards till 14. So both cannot coexist, my lord. Either if
Contradictory
cannot be that
stand.
they can't take a contradictory stand. So so far the second part is concerned, so far as irrigation sources it's the irrigation source or a water source, my lord. All that I can say that I have not been given an opportunity, nor I am in a position to say it was just an order straight away passed that you have to pay for it. So of course,
your agreement of 2014.
Yes.
Is it constructed on the premise that it is irrigation source or
government source? It's a government source. It's a government source. 14, they constitute it to be government source. Continued in 17, 18, government source. Till they changed it in 2020 as irrigation source. So now, my lord, my first submission to your lordships would be on the issue of refund, my lord, on the ground. My lord, I'll just to complete the facts, my lord. What happened, my lord? They are charging 2% interest, and it was then they demanded that extra demand on 5 crores and all. So I first came before your lordships. There was an interim order that you pay 50% and the 50% be stayed. Then I voluntarily filed an IA that I'll pay the entire amount because I don't want to pay that 2% interest.
It goes against you.
If it goes against me, that 2% interest will be like a multiple interest for me. In case I succeed, that's the interim order. Then you will get back my. But my first issue on the issue of the first part, that you cannot and should not keep when you yourself have recommended, keep it pending from 15. When I asked, and I've never, as per your own record, I've never completed more than, I'm not near that 6 Q6. I've never completed more than 6 Q6, and you have yourself have recommended me from 15. You have no reason to keep me that. So this I am entitled to refund from 15. When I applied for it and when you recommended, at least from the date of your recommendation, I should be entitled for refund of that amount which I paid on the extra because of not allowing me 10 Q6 to 4 Q6, which was the second part on the issue of this charging me from 14. Charging from 14 million, obviously I will be also asking for that is 14 to 20, whether it's irrigation source and water source, is a matter, though under the recommendation of the AG, the committee has sat down, but there's no opportunity for anybody to explain that whether it's a irrigation source or a water source. So this matter should be re-decided by the government after giving an opportunity to me. That is my second part for the additional part, because decision has been taken unilaterally by them and said that as per the decision, you have to pay. So these are the 2 facts, I can show to your lordships on the basis of which.
So number 1 is as to nature of resource.
Yes.
Whether it is government or irrigation.
Yes.
Number 2, as to the quantity of consumption.
The quantity of consumption is below 6 is undisputed.
Yes.
Only thing that quantity of consumption charges should be from the date on which I applied and asked and which you recommended, or finally when you actually agreed to reduce 18. This is the lordships kindly see, in this.
How can you just show me a few terms of your agreement?
Yes.
How agreement is structured?
Yes. So far as the agreement is concerned, my lord, the first one, agreement.
The first agreement, I will just read. Even put leave, then we agree. It is different.
My lord, your lordship sees, just note down page 47. In the list of dates, the dates are there, Lord. Page 47
is
the previous agreement under the river Birupa. Page 47, if you also get. Annexed. Yes. That is Birupa.
Any clause in the agreement which provides for varying the quantity?
No, that is not.
No agreement.
There is no
clause.
Condition.
Prohibition is there.
No clause in the agreement to change anything. There's no clause in the agreement. There's no clause in the agreement to change anything. But no clause in the agreement change from government source to water resources. that clause of not having, if strictly applied, will be applied to them also. Of not able to change from retrospectively from 14 from as they can't apply the clause to themselves and change from the government source to irrigation source from 2014 and say that no, I cannot change your clause. But and in fact, my lord, your lordships can consider their action in the sense 14 to 17 they forced me to sign the new agreement, but 17 I signed the agreement, but 18 they changed. Not that they didn't change, they changed it within 3 years. The next time. But kindly see, sir, in that Annexure 3, Annexure 2 is that for Birupa, Annexure 3 is for the present. That Lordship, this
2014 agreement, where
yes, that is 14.
Annexure 3.
Yes, sir. This is page 57.
Replace 57. Yes, ma'am. Yes. Yes. Lord, your Lordship says the volume of water, page 58, the volume of water 10.3826 and the river Mahanadi near Chaspada. There's a change, as I told your Lordship, from Birupa to Chaspada. And the rate, but there's no dispute that it is government water source rate. That is because that's the reason they have changed. There's no dispute that this is the rate applicable to government water sources. This is, Lord, your Lordship says, then kindly say,
the government water source or irrigation source, are they defined anywhere?
Yes, under the statute, Lord, Irrigation Act.
Irrigation Act is there.
Yes. There's an Irrigation Act. You have a copy? You have a copy?
Irrigation is a state copy. It must be a state act.
Yes, it's a state act. It's Irrigation Act.
Yes, irrigation.
This agreement is referable to any of the provisions of the Irrigation Act.
There is a format of the Irrigation Act. There is a format of the case. But I'll just take your lordships to a few definitions. Kindly turn to of the Act first. Then the rules are also relevant. Section 4, 6A. If your lordship saying Section 4, 6, small a. Section 4, 6, small a. Because the page may not tally, so I'm not giving the page number of my statute book. I don't know. If you also got it, Section 4, 6, Irrigation Act happened.
Definitions. Section 4 is definition.
Yes. The definition is 6A. 6 small a. Government water source.
Government water source.
Yes.
You are right.
That means any water.
Can I mark with
yes. Government water source means when the water source created naturally or otherwise by collection or deposit of water at a fixed place, any substantial water in a state of running, such as rivers. Because it is a river. If it's a government, it's a river, it's a government water source. If a lordship sees irrigation work, thereafter it is 9.
Yes.
All reservoirs, tanks, aqueducts, dams, wells, canals, barrages, channels, pipes, wells, tube wells, and artesian wells constructed, maintained, controlled wholly and mainly by the state government or panchayat, etc. Then B, my lord, all work, embankments, structures, supply and escape channels. But that means, my lord,
other than government will be irrigation.
No, whatever, everything is government. Every water is government. But if it is embankment, if there is an embankment, if there is a water is kept in a reservoir, that means under sort of a bound down by some structures, and the water is given from that structure, then it becomes irrigation water. That means actually irrigation water is meant for normal irrigation of villages. But apart from that, this water is also supplied to industries for which different rates are payable. If industrial rates are much higher than the normal water to the local villages, So this is, my lord, if it is embankments, it will come and if it is an embankment, then obviously it is an irrigation water and the rates are different.
Yeah.
My lord, then your lordships be pleased to see.
Water rate.
No, water rate your lordships will see. Before that, my lord, 23, your lordships is kindly. Yes. No,
23A.
23, no, rules, no, that would 23 of the rules. Lordship see that 23 are the rules. Lordship says 23 are the rules. Rules.
23.
A, capital A, of the rules, my lord. Yes. When an industrial, commercial, or other establishment proposes to draw or lift water from a government water source, then your lordship's query was there. The answer is in B. The executive engineer shall order installation of a meter or a suitable measuring device, as the case may be, and before making any drawal to cost, etc., and the flow meter, advised as the case may be, shall be installed. Then your lordship says it shall be installed, and the flow meter checked and all that. Then your lordship says this is a government water source. The government shall be two. Two is that the power of the government comes in two. The government in its water resource department shall be competent to grant license under the provisions of the Act to industrial, commercial, and other establishments on application in the following manner. The application shall be formatted in Form J. Form J I will also show to your lordships.
Yes.
Then the lordship says F, license fee shall be charged and collected at the rate and specified in the Schedule 3 as per unit or quantity of water actually drawn or allotted, whichever is higher, and shall be enhanced at the rate of 10% of till effect of 1st day of April. That means that as per the specified in the per quantity of water drawn or allocated, then whichever is higher. That means if you are allocated 10, you draw 11, you pay for 11. If you are drawn 9, but still you are liable to pay 10. Then no doubt on that. Then no doubt on that. Lord Daniel Lordship says
allocated or used whichever is higher.
Whichever is higher. Higher. Lord 26 he says 26 supply of water for purpose other than irrigation. For supply of water for any irrigation work for any purpose other than irrigation, the provision under Rule 33A shall apply. That means for water sources apply, for irrigation apply, and the rule, sir, is given in the schedule. Kindly see, sir, Schedule 2 and Schedule 3 Roman. Schedule 2 Roman, Schedule 3 Roman.
No, there is one Rule 31. Which is that? 31. The levy of water rate.
Yes.
Chapter 5.
Chapter 5, sir.
That is in respect of irrigation.
Irrigation. Then kindly see, sir, Schedule 2 and 3. This is rule, Schedule 2 and 3 is under Rule 23, 26, and Schedule 3 is under 23A. 23A is irrigation, 23 is water sources, government source. Kindly say, sir, special rates for purpose other than irrigation. They have given the rates, which is obviously, the rates are different for government sources and different for irrigation source.
Where you are it?
Sir, kindly see, sir, your lordship is left side column.
Schedule 2.
Schedule 2, special rate for purposes other than irrigation. That means irrigation water used for other than irrigation. Then your lordship is yes. Then your lordship is
rupees quantity.
Yes.
Purpose for which supply.
For water, in column 2 left hand, for water actually drawn or allocated, which is higher for industrial or commercial purpose. I come within that category, industrial purpose. Consumption not exceeding 5 cusecs, 4.20. Consumption of 5 cusecs more, 5.60. Then your lordship goes to government Schedule 3. Schedule 3 is for government sources. Schedule 2 is for irrigation sources, irrigation water.
Yes. Schedule 3 is government.
Yes, Schedule 3 government sources, then your lordship says consumption not exceeding 5 cusecs is 3.40, consumption which is less than 4.20. And the consumption 5 cusecs, 4.56. Because it's admittedly, my lord, it's more. Irrigation source, rates are higher. For government sources, the rates are lower comparatively. There is a comparison of losses. One is 4.20, the other is 3.40 correspondingly. One is 5.60, correspondingly is 4.50. And they all are agreements, we have been mentioned, and the government water sources rates. There is no doubt on that. Government water sources rates. Then, my lord, your lordship sees in then that 2000, what I'm humbly submit to your lordships, that once in principle, my lord, when I before your lordship sit, and I really enjoy to sit in lordships court, then I am remembered of a old time of Justice Hart. I'm not privy to it. Justice G.K. Misra was the Chief Justice of this court for 5 years. He used to, whenever she always to say that, give me the facts, I'll tell you the law. So I am just giving the lordship the facts.
I say, give me facts and give me laws. Along with Rasgulla.
But your lordship says, Lord, that in this background, that first of all, their decision not to reduce, that your lordships may independently consider their decision not to reduce the quantum of water
fixed under the agreement,
just after the agreement was signed, on the ground which is relevant factor that by deallocation of scope. That if losses get in that context, first I will get to learn what is my right to get it reduced and what is their, why should they withhold that amount and take extra when I am asking for reduction from beginning? I have not admitted to utilize more quantity than that. That is their account of executive. In that context, the first one, I tell something, Lord. And see, sir, my first letter.
Any provision in the Act for which gives power to alter what is agreed upon?
No, specifically, there is no provision.
No prohibition.
No prohibition, no provision. That is, no prohibition. No provision.
Only government can do that. In lean period, for purpose of public interest, government has power to reduce it.
Which is that? Where is that?
That is in the agreement itself. It has been written.
A3.
Because there is shortage of water in lean period. In
where is that source of power?
That is there.
No, that not there. I was not.
That was in your.
No, that was not restricting also, beloved. But that is because that power is my favor.
That's for
exigency.
Power is there.
But page 63
refusal to exercise becomes a ground for jurisdiction.
But page 63, what if he is referring to that, governments have liberty to review the water allocation unilaterally in case of exigencies. That there, Lord.
Yes.
That there, it helps. As your lordship, it helps. But page 63, your lordship says. Page 63.
Therefore, it is not that government has no power.
I'm sorry, but I thought.
Not in the same Annexure 3, my lord. Your lordship is looking at Annexure 3, which starts at page 57. My lord, it's at page 63. The relevant portion is at page 63 of the same agreement.
Paragraph?
My lord,
Last 32.
My lord, 32. Page 63 at the bottom.
Doesn't it drawing attention of the court to condition number, clause number?
Sir, 32.
32.
Yes.
32. Argues that even under the framework of the agreement, Annexure 3, power is available to the government to review the water allocation unilaterally in case of exigencies.
That is reiterated. Just in paragraph 33 also. Of course, just to retrace it, governments had liberty to review the water allocation unilaterally in case of accident. 32 and 33.
Pages 63, 64.
Then, Lord, from this background, Lord, in case of
what is the meaning of word exigency in dictionary? Go to Fowler's dictionary. How exigency, is it an English, simple English word or legal concept? See how Apex Court, I am not sure any Apex Court judgment, but there is one book, Supreme Court on Words and Phrases by Surendra Malik. Another book by N.C. Goyal,
famous book.
Words and Phrases.
Famous book. We'll find out later.
Just how word exigency is construed by the courts. Sometimes we don't follow the dictionary at all.
Yes.
We will only say law is not the slave of dictionary.
No, his general meaning is in legal terms, exigency, as you are also aware, exigency refers to a pressing need or urgent demand created by a special situation often requiring immediate action. In a state of affairs that makes urgent demand, such as for immediate.
The Black Law Dictionary defines it as means a pressing need, demand, or a necessity, often in context of a situation or circumstances.
Black.
NEC, Supreme Court on Words and Phrases. Surendra Malik, the editor of the SCC.
And I'm aware of
the gold medalist from Columbia University in LLM. Masters and a doctorate also. He has compiled the many decisions like the Ramnath. Go to Ramnath Iyer's Law Lexicon. Do you have facility of e-library?
They don't have the law, have the
Law Lexicon by Ramnath Iyer. He was a great law lexicographer. And at the declining age, he took Hamsa Sannyasa. And 4 or 5 judges of the Supreme Court went to his village in search of jurist Ramnath Iyer. The villagers did not know this. They said they used to call him as Baba. And his photograph is published in the latest edition of the Law Lexicon. In 4 volumes it is published. There is judgment. Yes. Not available? But in Law Lexicon it must be.
Yes.
It's there.
Some distance are there for exigencies, for situations warranting immediate action.
How he defined? Does it differ from Black Law Dictionary?
That is the US Supreme Court.
US Supreme Court. Just give that one copy. Thank you.
We'll also noting down, my lord, will give from the legal.
There is a famous judgment by Oliver Wendell Holmes. He writes, a word is skin of a living thought. Its meaning has no fixed contours. The meaning of the word depends upon the company of the words it keeps it. That's which Broom's legal maxim calls it as nocitur e socis. The meaning of the word depends upon the company of the words.
And the context in which
they like to put it this way, which Keats used to say, tell me who are your friends, I will tell who you are. Similarly, which are the other words besides?
True.
They will cast their shadow on this word.
True.
Like adjective generis, Yes. More or like adjustive judgment.
Two other factors in this context, Your Lordship, kindly keep in mind.
Yeah.
In this context of this, whether the power to change or not, in fact, they changed it in 18. Not that they did not change.
A new agreement.
17 there was an agreement. They changed it to 18. They changed it during the subsistence of an agreement. They ultimately changed it. Not this agreement. Subsequently.
In another agreement.
In my subsequent agreement, they changed it. So during the substances of agreement, now two things Your Lordships may keep in mind.
Yeah.
During the subsistence of my agreement, they actually changed it, which they could have done it earlier. Now all that I'm asking that they should have done it 15 instead of 18. They changed it in 18. They changed it in 18.
Let me permit that. Even during the subsistence of another agreement.
Subsequent agreement.
Of 2000, succeeding agreement.
Of 17.
Of 2017.
They changed in 18.
The government changed the quantity of allocation.
They changed it, the quantity of allocation, and allowed my reduction, reduced quantity.
Of allocation.
And allowed the reduction.
Downwardly revising.
Downwardly revised it in 18. Which I wanted.
At the request of the petition.
At the request of it. My request was allowed during the subsistence of an agreement, but the period taken for allowing the request is the issue before Lordships. Whether they are entitled.
In other words, at least from the date of application, they should have done that.
Date of application, date of recommendation. Their recommendation. Their recommendation.
Submits that. There was a recommendation in favor of the petitioner made by
the chief engineer.
Chief engineer.
In 15.
29/9/2015.
15. That the listed date.
Letter dated
29/9/2015.
29/9/2015.
Annex 9.
Sir?
Annex 9, madam.
Annex. Any rejection order is made?
Rejection for not giving refund.
Yes.
Is there? On the ground that agreement, I'll take your Lordship to that rejection order. Before that, my Lord, may I just take your Lordship that 88 order? 88, 88 minute recommendation which I sold. Page 88, my Lord, your Lordship says. Page 88. Lord Baker, have you also got page 88?
Yeah.
IMPA has applied in Form J for reduction of allocation of 6 cusecs of water from river Mahanadi for their plant at Chodwar. The industry, water from Mahanadi, the industry, etc. surrender 4.3 cusecs will allotted. The reduction in allocation from river Mahanadi, the Chodwar is hereby recommended with the following terms. We are not concerned with the following terms. They are procedural. To sign this, sign that, and other things, we are not concerned, but it is recommended from 10 to 6. You recommended in 10 to 6 immediately in
engineer in chief.
Engineer in chief.
Engineer in
chief. He recommended. That was kept pending.
Recommendation clause.
Beg your Lordships.
In which paragraph of the letter it is stated?
Yes, but the paragraph is. Yes, Lord. This last paragraph, Lord, your Lordship says. 18, right? You know what again? Now, the first paragraph itself says, I think that's 88. IMPA has applied one of the following.
Lord, may first
reduction, the industry has limited except recommendation.
Actually, allocation.
Yes. Is hereby recommended, if you also got it. The first 6 lines is hereby recommended.
Hereby recommended.
With the following terms, and we are not concerned with terms and conditions, they are procedural.
Recommendation as such has been made.
Yes.
Yes.
Subject to certain terms and
conditions. But that, as I told you.
On what ground government says no?
No. Yes. But in the government says no, finally for refund, because I have paid everything and after changing.
No, that amounts to saying no to do this also.
No, government first.
Government rejected your demand for refund.
Refund. Yes.
That is on ground?
On the ground that agreement period is there. because of the period of, because the agreement has 10 Q6, the agreement period is there. That your lordships get it in the first improved order. I'll tell lords, I'll take it to lordships.
Yes.
Yes, that is at 155.
Makes it 26 enough.
In fact, they also mention that there is a recommendation for reduction, if you also get it. Of course, nowadays government is also making paraphrasing their orders to make it little legalistic. whereas. If you also get it, whereas the little 2 pages I can place it before if you also permit me. The petitioner, etc., filed, etc., High Court not disposed to surrender water not exceeding revised agreement, but supply whatever reduced quantity of 5 men, not refunding the differential amount. Whereas the Hon'Ble High Court, etc., have observed, it is open for the petitioner to make an application for the state government for refund of money in a considered opinion. If a petitioner makes an application, the same shall be considered in accordance with law. Whereas on this, yes,
in that WP,
yes, sir.
Any objections were filed?
No. So far as counters, I'm not I'm not sure. I'll just check up. Objection any counter.
I don't think so.
Check. Probably, I mean, probably they must have objected. Otherwise, the court they must have objected. But by then, they had already revised, and hence the court directed that since it had already been revised, you ask for refund. But during the pendency of this case, they revised it. During the pendency of this case, which is before lordships, they revised it and reduced it.
No, revised it means another agreement.
Another agreement and
First
revised.
agreement.
First agreement.
Because
And
in
reduced.
that agreement,
Yes.
no, you can't say that it is reduced. Your agreement itself was for lesser quantity.
They made a fresh agreement during the for 18. In 17,
the word lessening is different.
In new agreement. New agreement.
New agreement.
They made a new agreement.
New agreement.
New agreement.
In the new agreement, whatever quantity.
They did it.
But it is not a case of reduction.
No, it's a case of
New agreement.
New agreement. It was, they made a supplementary agreement. They call it a supplementary agreement. They call it a supplementary agreement.
Supplementary to this agreement.
Yes. 17. The agreement to 17.
The 14 agreement A3 was for what period?
3 years.
17.
3 years.
Up to 2017.
Yes. 17 there was an agreement which I told the lordship, though they had asked me to reduce, last moment they said that you justify. I'm giving that letters are there. You justify how do you need less water. So because I had no choice, because unless there's a water, the company will not run, the industry will not run. So I made a fresh agreement in 17. That fresh agreement was changed by a supplementary agreement.
When
in 18.
Quantity is reduced.
Quantity is reduced. In 18. Then your lordship sees kindly in that letter of that rejection, whereas on receipt of lordship said High Court, the chief engineer water examined the application by accordance to law and found, your lordship says, the dates and everything is accepted. Only thing, the INFRA Chodwas applied for reduction of its allocation from 10,000 cusecs to 5.9 cusecs in September 2015. The Water Allocation Committee recommended the case to the government in Water Resource Department by letter dated 29/9/2015. After observing all official procedures and getting recommendation of the EPICOL, on 29/1/18, the government was communicated destination of reduction of water. That means the time taken from recommendation was 15. The time decision was made in 18. Is in the period, Lord. That's a whole case for this. That you can't.
When your WP was disposed of?
My 2017. My WP of the second WP.
26318.
Yes, I got to copy.
Well, 21/8/2018.
21/8/2018.
It is.
Yes, I got order also. Order for you.
We got the order.
Well, order. She got it. 21/8/18.
No, that is actually 26,318, my lord. I'm sorry, this is written wrongly. It's actually 26,318, the read petition number.
Correct. 26318.
Yes, sir. I've given the order.
Yeah. Well, one more read petition was there earlier.
Earlier read petition was there. because earlier writ petition was there for.
They permitted you to make the application.
That application. No, that
No,
70, that was
withdrawn.
That was withdrawn because of the subsequent. I won't say that why file an amendment.
You
Because
file application.
You file a new application. I filed this and withdrawn this.
Okay.
Given the order. And take the order.
17 order is Milord Lordship says is 21/8/2018, where the court says, in view of the subsequent development, the development is that by then a supplementary agreement was signed. In view of the subsequent development, it is open for the petitioner to make an application before the state government for a refund of money. The refund for this period, which is sought for. It is for the, if in a concept, it makes sense, same shall be considered. You see that, sir?
Yes.
Yes. So I was referring to that letter 26 as it meant to pinpoint the issue is applied in September, recommended in September, decision taken in 29/1/18. That is a substantially long period for which I have to pay on because you don't take a decision. It is like electricity, water, everything is chargeable. If I apply for an electricity meter, well, a smaller issue for a smaller individual, he applies that, no, I don't need this much, you give me a reduced quantity. If it does not allow, they will not charge for 5 years because they will not allow it. So they are...
Why you said, why you required lesser amount of water?
Deallocation of coal, Milord.
Which is that judgment?
That letter.
That judgment of the apex court.
I don't have that.
Where it made regulated.
Justice Lodha's judgment, Milord. Of course.
I need that.
Yes, I'll give you. I'll hand it. Justice Lodha's judgment where they said deallocation of the coal was deallocated. I was allotted coal. I was deallocated. So in fact, my representation was on that basis.
Your coal allocation earlier.
Yes, was
higher than this.
Big allotments.
You were allocated
was allocated coal block.
Coal mine.
My coal blocks, yes, sir. When the coal blocks got deallocated by the order of the Supreme Court, my coal block also went in the general of the whole time.
You stated. Yes.
I have said that because of deallocation, Milord, Annexure 4. I have said
866.
that was the ground, Milord, on which I applied less.
Yes, Your Lordship. Okay. Annexure 4, page 66.
What's the reason I applied, Milord?
You specifically stated.
Yes, that's my ground. Yes, we had drawn what if Lordship says. We are allocated 10% River Mahanadi near Chowpara in 11. We had drawn the water scheme and signed the agreement with the Egyptian. However, due to coal block deallocation, pursuant to the Supreme Court judgment, resulting in reassessment of a requirement, Blackwood now surrender 4.3 allotted water in existing 10.3. That means there is a question of surrender, sir. Surrender from what have been allotted. And in fact, I mean, the more the delay, it's a disadvantage to them because this officially they could have allotted to somebody else. So they are not deallocating me, charging me rate, and for 3 years. But and as you also see in the impugned order, they took 2.5 years to take that decision, which they should have taken immediately on my application. When I will not, like will not go, I make an application. If my application is there for reduction, if my application is for more, then you have certainly a assessment to find out calculation that whether there will be possible.
Now, how they will say that I need only one Rasgulla.
Yes.
How government will say, no, you have to take 2 Rasgulla.
That's exactly my case, Your Lordships. That exactly is my case.
There is a nova causa intervenus. The intervention of the apex court judgment. Because of apex court judgment, things are altered. Therefore, you made the application. You have stated that judgment also.
Deallocation. That's the only reason. Otherwise, then you would have needed.
You would have needed perhaps more water.
Water. At least this much. Because coal is not there, water is required for coal.
What I should do with
water? I don't need. But what I'm saying that I asked for 2 rasagollas, they gave me. When I asked them, no, I don't need 2 rasagollas, I want 1 rasagolla, Your Lordship said.
They said, no,
You justify that you want 2 and 1. First they said, in the meantime, that you justify you need 1, you don't need 2. That is their also order, but that they withdrew.
I'm just thinking, because
yes, ma'am.
Chitti on Law of Contract, Chitti on Contract, it is called, very famous book. There are 2 judgments of English courts where the agreement was to supply a particular amount of commodity. Somehow the commodity, so much commodity was not there, it was not known, not available in Bengal, those days. Then he offered, I can give only so much. The other side said, if whatever may be the condition, you have to give.
You have to supply the entire.
Supply. That is one set of case.
That
another one is
probably
my ship has sunk.
Will the Lordships call it as an impossibility of performance types?
It is not like it is partial frustration.
Partial frustration because of subsequent events.
This is a nova causa, therefore nova causa intervenus. Intervention of new cause.
New cause. Because of subsequent events.
Subsequent event.
As your Lordship said, the next example is ship.
Where the ship itself was not capable of carrying so much. They said, therefore, 1 ship we can take. He said, no, you have to take the entire. By that time, 1 ship was seized by the government. Then, because of her seizure, the court said they should supply only 1 ship full of material. There are 2 such cases. I agree, my professor.
I agree.
I've taken note down.
Whether a doctrine of nova causa intervenus will apply in the realm of contract.
Then, I was at page 155.
Correct.
Your Lordship says that Infa Chodwar, Lordship says in the middle, after observing our question 18, that Infa Chodwar has applied for reduction of water from 5.98 when its agreement meant for 3 years and force up to 17 for a quantity of 10. Hence, any claim for refund of excess payment of 3817 is not acceptable to the reason that the relevant agreement is valid for 3 years as per provision of rules. That Lordship says next page, the petitioner company renewed the agreement with the executive engineer, etc., with continual water drawal for running industry of the same quantity of 10 cubic. The relevant agreement was revised. Then your Lordship is revised. This I wanted to tell your Lordship then that the power of revision is in any case exercised by them, not that the power is denied by them. They are not denuded of the power. Was exercised by them. It is not denuded of that power. The relevant agreement was revised on 18. These monthly demand notice is raised by executive concerning the agreement quantum water as per the procedural rule. Hence, the question of excess payment made by the petitioner does arise in consideration of a faction, the application of petitioner claiming for refund of adjustment to the excess amount due to the delay to the June 18 for an amount of 5 lakh can be considered devoid of merit. Not some amount of malice in fact or in law can be there from the facts of this case from another fact angle which your Lordship may possibly consider. That this agreement that recommendation was in 15, from 15 to 17 continuously repented, nothing happening. In 17, my lord, this is your Lordship important. Your Lordship says, and 17, 6, 17, your Lordship, page 93, your Lordship says, just before the agreement was to lapse. Page 93. Page 93, sir.
Yes. An exact 10.
From 15, they did not do anything. But in 17, my lord, just before my agreement was to lapse, they write, my lord, Office of the Engineering Chief Water Resources, in enclosing a copy of the recommendation of engineering charge, it is requested for renewal of agreement with 6 cubic. My lord, your Lordship, in the meanwhile, 17 has come. That means the renewal period has come. They write that the renewal should be done in 6 cubics at a level as per the rule to avoid future complications. But this, then your lordships, my lord, in this context, my lord, then your lordship also, I'll kindly keep a note at page 84. I've given in my list of dates. The executive has given a finding that how much of your lordship asked me now how much I've been actually consuming. How much actually consuming is a report not from me, from the executive engineer. That is, below your lordship get it at page 86.
Less than
much less than 5. Much less than 5. Then your lordship is at page 84. Could have changed that. Slightly not very legible, but
page 84.
But your lordship get the entire chart at 86. That will be more clear, my lord. But chart at 86 by the executive engineer, provided by the executive engineer. What is the allocated quantity? What is the drawn quantity? Your lordship can see. I have been drawing less than half of allocated. Much half. Have you lordship seen that? Allocated, drawn.
Yes.
Much less than what has been allocated.
Water consumption. That judgment of the apex court came on which date?
My apex court judgment came 15. 14. And that low justice judgment, I'll guess 15. In this, what I was saying about this probably malice in law, if your lordship will see it, that 104 your lordship is 104 101 your lordship is Yes, lordship. Lord, your lordship says page 93. 93 I showed. But then they asked us, page 101. Your lordship says page 101. Page 101.
Yes.
Subject. Renewal of agreement in favor of infra. This is for 17. For the new agreement, 14 to 17. For drawal of 6 cusecs at Chaivasi. For that reduced quantity, they called us for renewal of agreement, right? My lord, if your lordship got it?
Yes.
Yes. Then my lord, your lordship is surprised to see few days thereafter in 103, they withdraw this letter. Your lordship is 103. The letter number, etc., dated 17/6/2017, issued from this office is hereby withdrawn. Let the renewal of agreement be drawn as per the previous agreement quantity of 10 cusecs. This, my lord, your lordship saw 17/6 was the annex at 10, which your lordship saw. Then after a few days, they withdraw this letter saying that no, it will be only done in 10 cusecs. Without any reason, Lord. Then your lordship said, right, and they said, asked about Rasgola. This is now Rasgola, my lord. 104 is, Lord, 104, kindly see, sir.
103 is withdrawal.
Yes, withdrawal of that letter, asking us to agreement without any reason. That 10 cusecs, and that's been the original amount.
Justify the reduction in allocation of what?
Justify. That means, as your lordship, I have to now justify why I am reducing my own water requirement, which you yourself approved, recommended 15. But this could be only not possible in normal circumstances unless somebody was trying to. I am direct requested to justify the reduction of allocation of water in 17. And I went on giving, writing the same thing, say deallocate. And then the lordship said I gave a justification because of deallocation. That is a 105. So this is the reason, my lord, I proved to your lordship, I humbly submit to your lordships, that this non-reduction from 15, when it was recommended, notwithstanding my application, when it was recommended, till 17 is one period, is the agreement period. Then 18 is the extended agreement period. Then you make a supplementary agreement. There's no reason not to allow me. When I have not consumed that water, I don't need that water. And I'm asking and my horses from my voice, please reduce my water quantity requirement. I don't need it. I have not deallocation of coal is happened. So this is the first issue before Lordship, is the major issue on my 18th. Now the second issue, my Lord, is interesting, Lord. Second issue is that asking it me that it is an irrigation water. And it's an irrigation water. That is there. That is, my Lord, your Lordship says,
not government source.
It's not government source. According to them, it's an irrigation source. In fact, the government itself said before them, that this is a government source. When all
CAG, they said that.
To the CAG, they said that it's a government source. But the CAG did not accept, so they thereafter sent a committee, and the committee sort of recommended that it's an irrigation source. Committee recommended thereafter it's an irrigation source.
But under the agreement, they proceeded.
And as a government source. As a government source. Till 18. Till
now they have changed the...
They have changed the irrigation, there's no dispute thereafter. I am paying as an irrigation source. They have also reduced the quantity, and that now there's no dispute of the future, because now it's an irrigation source. Now the reduced quantity, it's going on. And I'm paying for the current. Now it's for the past. When I asked for 5 crores, they asked 5 crores in return from me. When I asked my 5 crores,
they are saying that you only have to pay.
You have to pay 5 crores. That is the vision.
Where is that letter?
Yes, Annexure 33, page 195.
195.
Annexure 33.
Yes. But this is the first letter.
Others may not wait. This will take time. This don't interrupt also. We are in the midst of very serious matter involving the money, whose money. Yes.
Kindly, my Lord, sir, see 195. This is the letter. First time comes in 21. First time in 21, saying us, with reference to the above cited subject, it is to inform you that as per the audit report and subsequent high-level committee report, the applicable rate for the drawal of water from Mahanadi to Chaskoda is to be made as irrigation source and not government source. You have also admitted and signed the revised agreement with this office that the drawal point in village Chaskoda is irrigation source and made a payment. That's because of the subsequent agreement which I have signed. Accordingly, an outstanding area, this is the area, my Lord, demand note has been prepared from October 2014. My Lord, that's a starting point. October.
First agreement.
From October 2014 to January 2020.
Up to 2017, we can understand. 2014 to 2017, your defense can be understood. For that period, first agreement period, also they want to treat it as an irrigation.
Yes. Because the audit report says
Yes.
like that.
Yes.
You were heard in the matter?
No.
You were not heard. Nothing. It's just a letter.
What is the status of audit report?
The status of before.
There is one
Yes.
Controller and Auditor General of India Act 1951, 52, something like that. Take out that act.
Yes, sir.
59. 59.
But irrigation act of 15.
But as far as my little understanding of the control without the statutory provision, not because in fact my sister was the additional CAG, so I had a lot of discussion with her. They are highly recommending body. It is not a statutorily binding on any government, but it has a great value. But the government has to take an independent decision on the subject. They will point out that this is wrong.
That is 71, Act 71, 1971.
71 Act.
CAG and DPC Act.
No, and there are constitutional provisions.
Yes, but
This court consider
What
the
the
is also placed before the parliament. It's also placed before the parliament.
correct.
No, what I'm
It is tabled on the house.
yes, Milord. Milord, what
House.
Milord, what I'm humbly submitting to Lordship that the tabling of the report, if a CAG points out that this is an error in the, it's a matter of great importance. I don't dispute it, Milord, but it's not a matter of automatic compliance unless the government.
It does not have power proprio vigor.
Yes.
On its own.
Yes. Yes.
It has to be tabled in the house.
Yes.
Discussion has to take place.
Yes.
It should result into some order, effective order by the government supported by law.
Yes.
That's your
yes.
perspective.
And the government has to take an action. Lord, what I did that when they Lord,
There were three judgments of the apex court which considered status of CAG report.
Yes.
2G, co-allocation, even co-allocation, I vaguely remember. Of course, my memory is not that reliable nowadays, but still, more often than not, it serves me. The apex court has considered the status of the report.
Yes.
Yeah.
Status of the
that.
Yes.
Just Google up.
I was noting down.
Yeah.
This is the report.
Yes, ma'am. The basis on which the CAG said is at 210 that
The CAG report is at 210, Milord.
210.
Page number 210. If it starts at 209, it says Principal Accountant General.
No, I am not on that. Well, what happens to the report? It is treated at the house. It is tabled in the house.
no, that is there, but not,
Discussion takes place.
no, that is there. What I'm given to understand, Milord, when the CAG gives a report, he gives a report which is tabled in the parliament, but not that every objection is taken to the parliament. Not this type of reports are objections made by
No,
the
house also. This is a state matter, na?
No, this is not the house. This will be the procedure which they follow, at least, Milord, to my understanding, is that the CAG or the office of CAG, actually not the CAG himself, but the office of CAG finds some objections and sends it to the government. And the government considers it and gives its recommendations and decides. Not that everything is not to the house, Milord.
This is discussed by Subhash Kashyap
That
in his parliamentary
Secretary General. Subhash Kashyap, I think the Secretary General.
Yes, Secretary General. In his book, he has discussed it. He has dedicated one whole chapter
Yes.
as to how CAG report is treated. It's a very thick book, parliamentary practice in India.
Yes.
Very thick book, more than 1,000 pages.
Lord,
He has dedicated.
Lord, I will, when subject to government may be in a better position to say, this is a report from the Principal Accountant General.
Correct, because
So-
it states here.
Principal Accountant General to the state government.
Correct.
The Accountant General writes to the state government, and because of the Principal Accountant General letter, all this situation takes place. Now, so far as
Now, how on the basis of CAG report,
yes,
the agreements entered into under Article 299 of the Constitution or under the statutory provisions, the terms can be altered. That is the question.
yes. What happened, Milord, in this factual aspect, Milord, that kindly see, Milord, 211 on this, Milord, 211.
Last but one paragraph, Milord.
211,
Page
that
211.
principle of the letter, on this being pointed out in audit, Lord Secretary, on this being pointed out in audit, the government stated, May 2019,
211.
Again. 211. 211.
Yes.
On last but one paragraph, on this being pointed out in audit, the government stated May 2019 that water is supplied from Chaspada, which is about 4 kilometers from the storage area of the Mahanadi barrage. Since the intake well for supply of water to the company is not within the storage pond area of Mahanadi barrage, the supply of water to the company is from government source. That was the stand
Of the government.
They
say report is not acceptable.
Yes, they say it is but thereafter what happened, my lord? That thereafter, of course, they for whatever reason, they formed a committee that your lordship sees at page 206.
Yes.
Because of this and all this, they formed a committee. If lordship sees page 206.
What committee said?
They set a technical committee to look into the matter, which is a government source, that is irrigation source. One technical committee was formed by the engineer chief, etc., to ascertain the category of source of drawal by IMFA. The committee has submitted the committee's opinion that the drawal of water IMFA, etc., is irrigation water source. But these are the ex-party matter.
You were sorry,
they are not to anything, not proceedings, not notice, nothing.
This is dated 2/12/2019.
Yes.
But you entered into the subsequent agreement in 2018 only.
No. 18 was the water source for the government source. That
it also was government source. After this, you agreed that it is irrigation.
After this, I have made an agreement in irrigation source.
It is because
you don't want any other problem. Yes, yes, Milord, as your lordship knows, you run an industry in a state and you can't, coming to courts and also is an issue because to protect our rights. In 20, we made a final agreement. So on this, my lord, my submission.
They say since you have agreed in that agreement,
20,
it reflects on the earlier agreement.
Yes. On the second aspect, my lord, my submission to your lordship, I'll also, certainly, my lord, I will get it all clarified and given your lordships in the written notes or in the next date of your lordship. All these issues which are raised by your lordships. And the second issue, my submissions would be from 14 to 17, from 17 to 18, from 18 to 20, 6 years, you yourself
said government source.
It says government source. You contested before the audit that it's a government source. I came, that's the reason I was saying to your lordships, I came from Virupa, which was an irrigation source, to a Chaspada because it was a government source. Then thereafter, you unilaterally decide that it is a irrigation source. And not only decide, you impose me retrospectively from 14.
But let's say advocate submits that the nature of source of water, regardless of what the CAG said, could not have been treated as a irrigation source. When the agreements of 2014, 17 and 18 were structured on a specific premise that it was government source. First, he adds that even otherwise also, that could not have been done with retrospective effect without giving an opportunity of hearing to the petitioner.
That's I put that there. The only thing, all the clarifications I'll give your lordships in the next, Monday, Tuesday. By Monday or Tuesday, if you're all the clarifications which your lordships want on the statute also right now.
Bosch Kashyap's parliamentary practice. There is one chapter dedicated to
on CAG report. And your lordship also said the status of CAG report as discussed under 2G and coal allocation.
Yes.
And also, my lord, your lordship said Chitti law of contract, there's 2 English judgments, one on the commodities, which is of partial frustration, the principle of partial frustration, and the 2 C's, my lord. And my lord, your lordship said about the
Nova causa supervenia.
Nova causa supervenia.
Then word exigency.
Meaning of exigency in the legal concept.
repeated.
Supreme Court and
not I, your brother or friend gave that American judgment. I feel so happy. You will be suitably rewarded.
There is also a sage report, there is also Supreme Court judgment.
There is a Supreme Court judgment. I know that.
Yes.
Write down one more judgment. B.S. Yediyurappa versus State of Karnataka.
Aravinda Gupta versus India 2012. Another is Arvind Kumar Agrawal versus India 2013.
One judgment is referred by Karnataka High Court by Justice Ratnakala. I was one of the advocates. I referred to Subhash Kashyap. There is another book, English book, Parliamentary Practice by Erskine May, Erskine-May. Subhash Kashyap had drawn much from Erskine's book. It's a very old book, 1800 odd book, some 140 edition, something like that it is. Okay? This material you have to supply to entire books also. All right. Anything you want to say? Government. That American judgment, brother, you say.
Already handed over.
Yes, thank you, sir. So lucidly you have argued. So shant like Nile river flowing. Yes, sir.
My lords, will I start today?
I leave it to you. If you start, I am ready. Otherwise, I start dictating my notes in the office because I have to dictate. I should not forget what.
My lords, I have some preliminary objections. My first submission before my lords is that there is a concluded contract. The terms expressly stated in that contract is to be followed, my lords. Judicial intervention cannot be made to rewrite the contract or supplement or impliedly interpreting a particular. My lord, so far there is two aspects, my lords.
Learned AG and Mr. Behera submits contents that since the matter is purely contractual in nature, the arrangement has to be worked out under the terms of the contract, and that these terms cannot be rewritten by the High Court.
I love it. There are 2 points involved. It is one for refund and another for demand, my lords. So far refund is concerned, I'll make first my submissions. My lords, in the contract or in the act and rules, there is no provision for seeking reduction of the water. Quantity of
he submits that under the terms of the agreement, there is no right available to the contracting partner, the petitioner party contract to the contract, to reduce the agreed quantum of allocation of water.
Admitted.
Whether he requires or not, the petitioner would be bound by virtue of facta sunt servanda. Entire law of evidence is structured on facta sunt servanda. Do what you have undertaken to do. Abide by agreement on that. It's
mere one official recommending for reduction
will not bind the government. The recommendation made by engineer in chief.
No, that is executive engineer.
No, engineer in chief. In favor of the petitioner is a mere recommendation And that would not bind the government.
In absence of any provision in the contract,
In the absence of enabling provision or condition in the contract in question.
my lords, the first contract was for the period. My lords, one thing, another thing I am informing my lords. Earlier in 1988, first agreement was executed. That is for 500 and some odd cubic of water. In 92, they enhanced it to 10,000. This is background. I am just informing my lords. My lords, again in 2017, when the period was over, they entered into another exam. In the meantime, they filed a writ petition challenging the not considering that reduction. That was not adjudicated by this court, and it was withdrawn. So my humble submission is that the stand is not available to the petitioner.
Petitioner, earlier having approached this court, has withdrawn the petition, and therefore he cannot litigate.
And the cause in the writ petition was for reduction of the direction.
Wherein he had sought for and for reducing the quantum of consumption, allocation consumption. Now it is not open to him to re-agitate the scene.
My lords, I'll refer to two letters. That is 17/6/2017 letter.
Can we do it
No.
next day?
Yes, sir. It will take.
I may be pardoned, my lord. I have got some difficulties tomorrow, and I have a matter in the weekly list, which may likely reach tomorrow. I pray, my lord.
Will not take your matter. Don't worry. Where you want to?
My lord, tomorrow is Saturday. Normally, here practice is 1 hour or 2 hours.
It is my duty to bring it to Lordship's notice, since I am badly.
I am agreeable with you. Tell you what to give. I bring up your matter.
25th?
See that.
25th?
Matter should not be.
25th? 24th?
Which date you want?
25th, sir.
25th.
Not a bad notes, all everything will be ready.
26th will be the last one.
No, 25th, sir.
You are asking for 25th. But 26th is the last.
No, the 24th, no?
I don't want to keep these matters. I want to give.
No, 23rd or 24th next week.
Not this one, that other
That Alada.
Or
23rd?
Otherwise, I have to give.
My lord, this side. My lord.
No, sorry. This is 22nd is the Monday, 23rd is the supplementary list Tuesday. So if you also call it on 23rd, or tomorrow is only because you can't get all this in tomorrow, only all this homework. 22nd, 23rd, anytime?
24th, all right.
Yes.
23rd, all right.
23rd. 23rd.
Otherwise, you keep it on 25th itself. 25th, so that I can pronounce the judgment during holidays. I pronounce it afterwards.
Your Lordship's pardon, on 28 has been shifting day by day. Your Lordship, the petitioner is without salary for 2 months. Your Lordship had asked for compliance of the order of the Supreme Court. Has not been compliant. Your Lordship. 5 dates have been taken.
Now you know what pressure I have to pay.
Only your Lordship has asked for to comply.
With us. We'll keep this one with us.
But your lordship might have marked. Your lordship might have marked it, so your lordship.
Let it be this.
28 may kindly be put.
No,
My lordship, also matter will come tomorrow. A matter was passed over 24.
Any urgency, brother?
Yes, sir. My bank guarantees are with the lower court. They're not releasing.
Bank guarantee.
If you remember, the fabric rolls were seized in a narcotics case, wherein I submitted my bank guarantee for
The urgency. We'll take it immediately after vacation.
My lord, 20.
Call this matter immediately after vacation.
Okay. My lord, 28 may kindly do.
20?
May kindly do put for tomorrow.
Tomorrow.
Monday. But my lord, the petition has something.
Monday you put.
Go like welcome.
Thank you, sir. Thank you, sir. So much I learned from you. Yes.